Okay, so I'm going to go in and I'm going to share my screen and I'm going to
Hi, Riddick. Can we get a sound level on you? Would you turn your mic off and speak for me?
Hello? Can you hear me okay?
Can you hear me pretty well? If there's any way to turn it up a little, that would probably be good.
Yeah, I can. What's this sound?
That sounds better. Can you, pretend to introduce yourself?
Okay. Your Honor, my name is Rick Liskey. Does this sound good or does it need to be louder?
I think that's good.
I can make it louder just in case. If you...
Okay, a titch louder never hurts. Ava, could you unmute and can I hear your volume?
Hi.
Okay, you sound clear. Could you just say a couple things?
Good afternoon, Your Honor.
Yeah.
My name is Ava Corey.
Loud and clear. Perfect. Thank you. Grant, would you unmute so I can test your volume?
Hello.
Good. Yeah. Can you say a little more than hello?
Good afternoon, Your Honor. My name is Grant Fuller.
Awesome. Maybe a teeny bit louder if you can, but I can hear you.
How do you turn the volume up?
So if you go by the microphone where it says mute, there's a little arrow and you can hit it and go to audio settings, which is at the bottom of the menu.
Okay.
And then there's a general volume you'll see for the speaker and the microphone.
Ours is maxed, so I guess we
Okay.
got what we got. Okay.
That's perfect.
All right, thanks.
And make sure the automatically adjust volume is turned off.
Where's that at? Let's see.
So we want it to be left. It's right. It's on the microphone part.
Okay, there we go. All right, we're all set.
Awesome. Ariella, can I hear volume?
Good afternoon, Your Honor. My name is Ariella Johnson.
Yeah. Awesome.
Lenore, are they going to
Yes.
have a break after the coin toss to get ready for whichever part they're playing?
Great question. So that they know whether they're defense or prosecution, and that gives them a moment.
Right. And they, like, Ariella needs to change from lawyer to Barbara Barrett and things. I'm
Okay,
sure others
depending
may
on
need to
what
do
the
that too.
coin toss is. Yeah,
Right.
sure, absolutely. We can do like a 5-minute. Let me see in the script where that might come. Administrator, what do you think on that? I don't think Shelley can.
Hi, I'm here. I was just looking. I need you to screen share. I'm getting the same message as yesterday that I can't screen share. So I need you to enable that.
I can do that. Yep.
Awesome. And I think, well, what we could do is, I didn't know if you guys want to actually coin toss in the moment since we're online, or if we should do it like right now in a few minutes, and then they would know what they're going to do. It's up to you guys. I have a binary dice that I'm going to roll and put the camera on so you guys can see it. So it's up to you.
Yeah, let's just do the coin toss. Why don't you pop on camera and do it? And that way the kids will have the next 8 minutes to prepare.
The camera rigs. And I still need to get dressed.
That's okay. We all
wear a t-shirt. Okay, so for all intents purposes, guys, I have a binary dice. It's 0 and 1 binary, right? And the teams, don't forget, this will be in a minute when I go share the spectator, but this is kind of just welcoming people. So team A is Kirkland Kent, okay? And
I'll
team
put it in the
B,
chat, yep.
yeah, team B is Issaquah and North Bend. So do we want someone to, do we call it? Do I just say like team A is 0 and team B is 1, or what do you want to do, Lenore?
Yeah, you can just call it. We're good.
Okay, so I'm gonna have Riddick try to like put the camera on me while I roll. Okay, so team A, who is Kirkland and Kent, will be 1, okay? And team B, who is Issaquah and North Bend, will be 0, okay, Riz? So your teams are 0 and the other team 1. Okay. Oh yeah, no, you get to choose, I think it was, right? They get to choose.
Yes, whoever wins the coin toss chooses if they want to do prosecution or defense.
Yeah, so you'll need to talk to your peoples in just a second. Okay, here I am rolling. It's kind of crazy screen. Woo! Okay, so So it's a 1, which means it's Team A goes first, Kirkland Kent.
All
and
right, you guys choose.
Yeah, they decide and choose. I'm gonna leave Riddick here and I'll be right back.
Okay, great.
I'm gonna do screen share that.
And I'm gonna fix the screen share. How did?
So, yeah.
I can't see if all of Kirkland Kent is here. I don't see Ashlyn. I don't, oh, there's Ashlyn. Wait, no. Yeah. Okay. What about I don't see the Hung Singers.
Yeah.
Oh,
I'm letting in the Cushman family. Trin, you'll have to mute while I'm talking.
Yeah, we're just missing the Hansingers.
Great. Ethan, can you unmute really fast so I can hear your volume?
Yeah.
Perfect. Thank you. You can mute again.
Okay, cool.
Natalie Schubert, can we hear your volume while Kirkland Kent decides what they want to do?
Is this loud enough?
That's good. Thank you. Clear. Ashlyn, could we do a sound check with you?
Can you hear me okay?
Perfect. Genevieve, would you mind unmuting so we can test your audio?
Is this good?
That is good. Thank you. If you're a juror or a parent, you can simply remain video off the whole time. You can do that with the stop video button in your bottom left corner. So any participants that are not actively participating in the trial will just be the black background. Itsuki, would you mind unmuting so we can test your audio?
Hello. Is this good?
That I can hear you, so I think that's good.
Hello? Am I hearable?
Yeah, who's doing the speaking at the moment?
Jay Constant here.
Okay, yes, you loud and clear, thank you.
Jake, can your mom get on screen for a minute? Hi, Kim. I don't know if you saw my text. They rolled the die and we are up first, as in we get to choose if we want to do prosecution or defense. We never discussed that scenario. So
Oh, that's because I thought the way it's scripted in the thing is that you roll to see who does prosecution first. Do you have a strong preference, Grace?
I don't think my team has a strong preference. Team?
Good afternoon, Honorable Judge. We are just settling on which team will be doing prosecution or defense first. So with us.
Thank you.
You're welcome.
If there was no strong preference, then I would say, I think it was scripted that whichever team won the toss would do prosecution first. So we would just do prosecution first then.
It says that in the order of events sheet, it says that the winner decides which team does prosecution first.
Hello?
Well, good to know that I can misread things.
Hello? Hello?
Hello, who is saying hello? Can we have a name, please?
Hello? Mom, the mic doesn't work.
It's working.
No,
I can hear you.
hello?
It is.
It only picks up the voice.
Is
Hello?
that Christopher talking?
Hello?
Okay, I'm gonna text. I think it is Christopher.
Yeah, Christopher, we do hear you. All right, Shelly, why don't you see if you can screen share now? I've made you co-host, I believe. All right, so was that sorry, we got interrupted with a few more people doing sound checks. Was that Kent Kirkland, you're going to move forward with prosecution and should have your witnesses prepared for that?
I'm just looking for confirmation from Grace that
Sure.
that works for their side.
Sure.
Sorry, we couldn't get unmuted there. Yeah, I think that we're fine with that, Kim. Go ahead with prosecution first.
Hello?
Hi, Christopher, is that you?
Yeah, that's Christopher. Hold on.
Okay, great. We can hear you. Awesome. Let me see. Do we have any people remaining? Are we missing Rachel Arnold? She here? And I want to make sure if you are a juror and you are present, perhaps you could unmute and say present. I do see Jessica Besso. She's labeled herself juror, so that's awesome.
I'm present.
Thank you.
Jean Rule's present.
Thank you, Jean. Awesome.
Angela Macy Cushman present.
Woo, all right. Okay, our 3 jurors are here and present. Awesome. Shelley, could you do the screen share? Yes or no? I know you have to go over to Riddick's computer for
Hey, Lenore, I'm here. I just emailed you a PDF of the Spectator because I can't share it from my desktop or drop in the clean files for the mock trial exhibits. So can you pull it up in your email and add it to the mock trial clean copies and I can share from there?
Yes, indeed. I will get right on that.
I'll run right back to my computer.
Okay, that should be done for you, Shelley. All right, so Kirkland Kent, is everyone present as far as students?
I'm here.
I'm here. Appears to be all present.
Okay, great. Issaquah North Bend, are we waiting on anybody?
I think just Rachel, right?
Just Rachel. Okay, I will go make a phone call because I think we are almost ready to begin. All right, so North Bend Issaquah, you will be performing defense, so please have your roles ready. That means our Barbara Barrett and our Dana McGuire will need to be in character. Thank you so much. This looks great. Rachel will be on shortly. She's the last one we're waiting for. Let me open up my posting thing. All right, guys, at this point, once Rachel logs on, once I let her in, you will not see me anymore, and it will be all communication directed to Shelly as administrator. But I am the host, so if someone gets kicked out or something happens, I will be monitoring to let you back in. I will also handle sending you to the breakout rooms after round 1 and after our second round. So thank you for your patience, and we'll get going when Rachel is logged on. Did anyone else not get a sound check?
I didn't.
I don't know what you want to do.
Okay. Sounds like I can hear you. So that's good.
Lenore, let me know when I go to welcome everyone and do my opening welcome if you want me to stop screen sharing the program, or I can leave it up until I leave.
Yeah, I think actually we'd like to see you. So probably we don't need to share that during that time, but it's been have it up to read right now. Thank you so much, Shelly, for putting that.
You're welcome.
Hi, Rachel, are you logged on? Can we get a sound check of you very quickly to
Hello?
hear you?
Can you hear me?
Yes, is there a way to turn it up a little bit?
I don't know.
Okay, well, I can hear you all right, so let's roll with that. Okay, administrator, I believe we are all present.
Hi, good morning, everybody. Everybody's here. Awesome. I'll go ahead and get us started. I just want to say thank you so much for coming today. My name is Shelly Liskey, and I am a director at Classical Conversations, a homeschool group that we educate with. And I have the privilege of being your administrator today. You will see me on camera, and there'll be times that I'm off camera, but I am monitoring and pulling up exhibits for the attorneys and also helping with chat and breakout rooms. But before we get to the proceedings, I just wanted to share with you a little bit today of why we're here. As home educators, we have the privilege and the freedom of teaching our kids the best way that we believe they learn. And part of that is that we get to participate in a Classical Conversations homeschooling group, which means we get to educate classically. I know many of you already understand what home education is, but classical learning means that in somewhat simple terms, that we believe God is a God of order, from the creation of the world to each tiny hair on our head, that he has ordained the time and places that we live and where we are and how we learn. And the stages briefly are grammar, dialectic, and rhetoric. And what that means is that when we're younger, we take in a lot of information, we absorb facts, we like to hear stories over and over again. We're like little sponges, and we take lots of information in. And when we get to that dialectic stage of learning, that's when we start to question lots of things. We start to ponder all of that vocabulary and grammar that we learn when we're younger and start to think about it and ask lots of good questions. And when we become rhetorical, we start to take those questions and form those into our thoughts and think about everything from why the world is the way it is, why we believe what we believe, and who we are. And so today in the proceedings, what that means for Challenge B, the students that are with us today, it means that they've taken the grammar of a mock trial. They have a mock trial notebook that they've worked through, and they've taken the grammar, they learned the vocabulary. What is an exhibit? What does prosecution mean? What does burden of proof mean? They have to think about those things. And then for the dialectic stage of that learning, they've started to take all of that grammar and put it into forms of questions, meeting together in groups and thinking about it, pondering over it, asking good questions. Why is this way? Why does the judicial system work in this manner? And now they're finally here after 15 weeks. That's a long time to be working through a project together, and teamwork, all of those things come into play as well. But they're at the rhetorical stage now, where roles have been assigned through that mock trial notebook, and now they get to play that character or that person that they've been thinking about and why they made the choices that they did. And so that's what they're presenting to you today. They're going to be presenting in 2 rounds, and we have 4 teams with us today. But through that, they're going to be able to apply the evidence. They form strategies on what they've learned, and they've poured over this notebook for 15 weeks. And so they're excited to present that to you today. We are grateful for the Honorable Judge Anthony Kipe, who is with us today. Thank you for participating and proceeding over this mock trial. Another thing I should share with you is you might be saying mock trial, what does that mean? Well, we're obviously not in a true courtroom, and these are students, they are not attorneys by law, but it's a process to be able to walk through and participate in kind of like a rehearsed, ordered way of learning about the legal system in a competitive manner. Our students today will act as attorneys and witnesses, like I've shared, navigate that judicial system, and then we'll come to maybe an understanding of what a trial consists of and playing the roles and all that they do. Okay, so I'm going to introduce a few more people and then we'll get to the logistics of today. We have 4 classical conversation homeschooling groups with us today. Challenge B director for Iss K is Cheryl Nelson. We have the director for North Bend, who is Lenore Deviney, and you saw her earlier, and she's going to be off to the side monitoring chats in the chat box and breakout rooms, but she's pretty much not going to be visible like she has been in the previous week. We'll also have Grace Johnson from Kent, and then Kim Hossinger from Kirkland. And so these 4 classes have joined together because classical learning is typically smaller groups, and we've joined together to form this mock trial team. Let's see who else. Oh, logistics. So for the purposes in case of this trial, we would ask that everyone keep their cameras turned off and their mics muted, unless otherwise you're participating in the moment of the trial. Say you're attorneys. You need to have your mics on so you can do objections or ask your questions. Witnesses obviously need to be on camera and their mic on, and of course our honorable judge that's with us today. Parents are proctoring aside their students today, and what that means is being classical educators and having a biblical worldview, we want to proceed through honorable notions. We want to be above reproach, and we want to make sure that we proceed in a manner that's worthy to the Lord, meaning that we're not going to have coaching and we're not going to have notes to the side, but we're relying solely on what we've worked on the past 15 weeks. So parents are beside our students, but not visible on camera, but they're just maintaining the order of the household. Let me see anything else I have in here for logistics before we begin. I think that is pretty good. We'll have breakout rooms during breaks so students can go in and chat for a minute with their teams, and there'll be adults in those rooms, again, monitoring, being above reproach, modeling integrity. And I think from there, we're pretty much ready to begin. I've gone over the logistics, the breakout rooms. I'm just making sure I've gotten everything since this is so different than being in a courtroom. Okay, I think I'm pretty good. So I'm going to pray for us. I think that's good to start with prayer, and then I will begin opening the proceedings. Lord Jesus, we just thank you so much today. We thank you for the opportunity to home educate. We thank you for the opportunity that we have as home educators to look at how we learn, how you created us and created the world, and that we can walk through those stages of learning with our students to become hopefully confident, lifelong lovers of learning, that they will take what they've applied and that they will use it in the world, just like we're doing today with this mock trial. We're thankful so much for the jurors who have been able to come on Zoom and participate with us. And of course, Judge Kipe, thankful for all the students and their hard work. It's not easy to participate in something like this when we're not together in our teams. And so I thank you so much, though, that you have provided us with technology so that we can have many people online together at once proceeding, and that we can stream so that family members who can't be with us for social distancing reasons and can watch. We just thank you so much, God, and ask that you would give favor to us as we technically run this trial. And again, Lord, I just thank you for everyone who has participated, from siblings being quiet when their other siblings are running through questions, to parents being patient, to the students working as teams, and everyone else that has come alongside us to make this a memorable journey in our learning. We thank you so much for that. And with that, God, we just pray that you would be with us and keep us safe. And we love you, Lord. Amen. Okay. I am going to grab my sheet here. So the Superior Court of Milton County is now in session, and the Honorable Guide presiding. God save the state and this honorable court.
All right. Good morning, everyone. I apologize. I don't think I've met counsel or the parties yet. I just wanted to say a few things. All witnesses are presumed to have been sworn and testifying under oath as if in court, and sworn to tell the truth. All counsel are bound by the rules of conduct and ethics for any courtroom, meaning they should not advance any facts that are not provided from the record, and they should follow all courtroom decorum rules as to how you present arguments and objections. Finally, I'll ask you all, because we are in video conference, try not to talk over one another. And when you're making an objection, make it short and to the point. All right. If I need further argument as to an objection, I will let the parties know. All right. Lastly, I want to thank you for giving me the opportunity to assist you all. I was a trial attorney for 20 years. I was an intelligence analyst for the federal government for 10, and I've been a judge for 7. And so I want to thank you for letting me participate and assist with you. These sorts of exercises are important for the public to see and for students to participate in, because very few of us actually know how our courts work and see how they work. And this is a good opportunity. And if any of you are at all interested in a career in the legal profession, at some time in your future, feel free to ask me. With that being said, the prosecution today, this is a jury trial. So to my jurors, I'm going to ask that you pay attention to all evidence. The burden of proof is proof beyond a reasonable doubt, meaning that after consideration of all of the evidence, you find that there is no reasonable doubt as to guilt, you must find guilty. If you find that a reasonable doubt exists, then you must find them not guilty. Administrator, what is the case today?
Your Honor, today's case is the state of South Carolina versus Barbara Allen Barrett.
Okay, are the parties ready to proceed?
Yes, Your Honor.
Okay, for my record keeping to keep track, can I have the names of all counsel for the prosecution first?
Good afternoon, Your Honor. My name is Jake Honsker. I'll be direct examining CM Cheney, cross-examining Dana McGuire, and reading the closing statement. May my co-counsel and witnesses introduce themselves?
Of course.
Good afternoon, Your Honor. My name is Genevieve Zahler, and I will be direct examining Dr. May, cross-examining Barbara Barrett, and giving the opening statement.
All right, thank you.
Good afternoon, Your Honor. My name is Ariella Johnson, and I will be doing the direct exam of Lee Porter.
Thank you, Ms. Johnson. Anyone else for the prosecution? For the defense? Counsel for the defense.
Good afternoon, Your Honor. My name is Rick Liskey, and I'll be doing the opening statement and cross-examination of CM Cheney. May my co-counsel and witnesses introduce themselves.
Of course.
Good afternoon, Your Honor. My name is Trinity Divini, And I will be direct examining Dana McGuire and direct examining Barbara Barrett.
All right, thank you, Ms. Diviny.
Good afternoon, Your Honor. My name is Christopher Bond, and I will be cross-examining Joe Armay.
Great. And the parties and witnesses, who are they going to be?
Good afternoon, Your Honor. My name is Hannah Nelson. I'll be playing Barbara Barrett.
Thank you, Tana. Next person. Your mic's not on.
Good afternoon, Your Honor. My name is Rachel Arnold, and I will be playing Dana McGuire.
Thank you, Ms. Arnold.
Good afternoon, Your Honor. My name is Ashlyn Anderson, and I will be playing Lee Porter.
Thank you.
Good afternoon, Your Honor. My name is Iss K Smith, and I'll be playing CM Cheney.
Thank you, Itsuki.
Good afternoon, Your Honor. My name is Grant Fuller, and I will be playing Joe Armay.
What's that last name of the role you're playing?
Joe Armay.
All right. Thank you, Mr. Fuller. Okay. All right. If the parties are prepared to proceed, we have an indictment before us on one count of first-degree murder. For the defense, what is the plea? Guilty or not guilty?
Not guilty, Your Honor.
All right. A plea of not guilty puts all factual issues and legal conclusions at issue in this case. Do the parties have any pretrial motions?
No, Your Honor.
No, Your Honor.
All right. Then we're going to proceed to opening statement. As is usual, the city has the first opening statement. Prosecution, you may proceed.
May it please the court, Your Honor, and members of the jury. My name is Genevieve Zahler, and these are my co-counsels Jake Hunsinger and Ariella Johnson. On the night of December 18th, John Walker Barrett was brutally murdered by his wife, the defendant Barbara Allen Barrett. Mr. Barrett had arrived home later than usual, around 9 p.m., and told his wife he desired a divorce. The next time the couple was seen, Mr. Barrett was dead on the floor, and Mrs. Barrett had locked herself in a bathroom. The issue at hand today is whether or not Mrs. Barrett murdered Mr. Barrett. We will prove that Mrs. Barrett killed Mr. Barrett with both malice and forethought, thereby making her guilty of murder. A letter found in Mr. Barrett's hand will prove that he did not wish to harm Mrs. Barrett. A diagram will show that Mr. Barrett was attacked, and a police report will give a detailed description of the crime scene. Our first witness will be Lee Porter, the Barrett's housekeeper. She will testify to having seen Mrs. Barrett practicing with the gun that very morning, having been at the house at the time of the shooting, and to seeing Mrs. Barrett with a gun pursuing a severely injured Mr. Barrett. Our second witness will be CM Cheney, the reporting police officer. He will testify to having seen the house in great disorder, producing a diagram of the crime scene and writing a police report, as well as to Mrs. Barrett stating that Mr. Barrett had not threatened her. Our third witness will be Joe Armay, the medical examiner who examined the body of John Walker Barrett. Dr. May will give a detailed account of bullet locations, show that Mr. Barrett was killed while lying down, and illustrate the positions the deceased was in when shot. From the statutes of the state, we see murder defined as the killing of another person with malice aforethought, either express or implied. Through this evidence, we will prove beyond a reasonable doubt that the actions implemented by Barbara Barrett on the night of December 18th constitute murder of the first degree. I and my partners will prove to you that Barbara Barrett murdered her husband on the night of December 18th. Thank you.
Thank you, counsel, for the defense. Are you ready with your opening statement?
It pleases the court, Your Honor, and ladies and gentlemen of the jury. My name is Rick Liskey, and before I make opening remarks on this case, allow me to introduce my co-counsels, Trinity DeVinny, Natalie Schubert, and Christopher Bond. This case is about a battered woman who used a gun in self-defense against her against her husband, John Barrett. This act of self-defense saw resulted in the death of John Barrett. The issue in this case today is whether Barbara Barrett truly acted in self-defense or planned to murder John. The evidence in this case will show that after an uncomfortable dinner, drinks were poured, a letter exposed John Barrett's feelings and broke Barbara's heart. The evidence will also show that in a moment's notice, Barbara had to make a life or death decision. Our first witness will be the accused, Barbara Barrett. She was in a cycle of abuse for years in which her abusive, disrespectful, and often drunk husband threatened her life. Our next witness, Dana McGuire, has practiced for more than 17 years as a therapist, has worked with over 300 battered women, is an expert on domestic violence. She has been counseling Barbara Barrett in regards to her cycle of abuse, beginning 2 weeks after her shooting. The prosecution wants you to believe that Barbara Barrett intended to murder her husband off of hate and grudges. But we will prove to the court that Barbara Barrett did not mean to kill her husband, but purely acted in self-defense.
All right. Seeing no further opening statements, the court will move and ask the city to proceed with its case. You may call your first witness.
Thank you, Your Honor. I would like to call Lee Porter to the stand. What is your name?
Lee Porter.
What is your occupation?
I'm a housekeeper.
Did you work for the Barretts at the time of the shooting?
Yes, I did.
How long have you worked for the Barretts?
I've been working for the Barretts for about 6 months now.
What do you do at the Barretts' house?
I cook and clean for them.
What are your hours?
My hours are 2 p.m. to 10 p.m., Wednesdays through Sundays.
Have you ever seen any physical violence between Mr. and Mrs. Barrett?
Other than the night of the shooting, I hadn't seen any physical violence between them.
On the night of the shooting, did anything odd happen earlier?
I did hear a sound like a car backfiring, and then Mrs. Barrett came through the door that she never uses holding a gun.
Was Mrs. Barrett complaining about anything before Mr. Barrett got home on the night of the shooting?
Yes, she was complaining about how Mr. Barrett was always coming home late.
What was the mood in the living room when you went to tell the Barretts that dinner was ready?
They both looked upset and they were arguing.
What happened at dinner that night?
They continued to argue until Mr. Barrett told Mrs. Barrett to leave the room.
Did Mrs. Barrett say anything before leaving the dining room?
Yeah, she said something like, "You'll be sorry."
What happened after that?
After that, I heard 3 loud noises that sounded like a car backfiring, and I went to see what they were.
And what did you find?
I found Mr. Barrett running into the dining room.
How did Mr. Barrett look?
His arm was bloody and so was his leg, and he looked really scared.
Did anyone else come into the dining room?
Yeah, Mrs. Barrett came running in after him, and she was holding a gun.
What did you do after that?
After that, I ran outside and stayed out there for about 10 minutes.
Where was Mrs. Barrett when you came back inside the house?
She was locked in the downstairs bathroom, and she was crying and screaming.
What was Mrs. Barrett screaming?
She was screaming that she loved Mr. Barrett and didn't mean to hurt him.
Thank you. No further questions, Your Honor.
You may cross-examine.
Have you ever heard the Barretts argue?
Sometimes they would argue.
Have you ever heard Mrs. Barrett scream after an argument?
I did only once, yes.
Okay. And then you said earlier during the day of the shooting, you heard a noise like a car backfiring and you saw Mrs. Barrett with a gun. Did you actually see Mrs. Barrett shoot the gun?
I didn't see her shoot it, no.
And have you ever been in trouble with the law?
I was once.
No further questions, Your Honor.
Anything on redirect? Does the city have any questions on redirect?
No, thank you, Your Honor.
All right, the witness is excused and may turn off your microphone.
Thank you, Your Honor.
City's next witness.
Thank you, Your Honor. I would like to call CM Cheney to the stand. What is your name?
CM Cheney.
What is your occupation?
My occupation is Milton County Police Officer.
Did you attend college?
Yes,
What did you study there?
I studied criminal justice.
Are you taking any advanced classes in police work?
Yes, I have taken 9 hours toward my advanced degree in criminal justice.
Prior to the shooting at the Barrett's house, had you ever been dispatched to the scene of a homicide?
Yes, on numerous occasions.
What are the actions that you take at the scene of a homicide?
I preserve physical evidence, take physical proximities, and interview witnesses.
Was there anything different about your assignment on the night of the homicide at the Barrett's residence?
No, but my partner was homesick.
Who reported the homicide?
Lee Porter, the Barrett's housekeeper, was the reportee.
In what condition was the reportee?
Hysterical and crying.
Where was Mrs. Barrett when you arrived at the scene?
She was locked in the downstairs bathroom.
What happened after she opened the door to the bathroom?
She fainted.
What was she saying after she revived?
She was saying that she loved the deceased and that she did not mean to hurt him.
Who was the deceased?
The deceased was Mr. John Walker Barrett.
What appeared to be the cause of death?
Several bullet wounds to the body and one in the head.
Where was the deceased?
The deceased was in the dining room, with its head approximately 2 feet from the breakfast room doorway.
Your Honor, I would like the administrator to bring up the diagram of the house.
Administrator may publish that.
Your Honor, can you see the exhibit?
Yes, thank you.
Officer Cheney, can you see the exhibit?
Yes.
What is this document?
This is a map of my making showing the scene of the homicide with important facts.
Your Honor, I would like the diagram of the house to be entered into evidence as exhibit number 1.
Any objection from defense?
No, Your Honor.
So admitted.
What does the blood stain on sofa 2 indicate?
It indicates that Mr. Barrett was shot in the arm while sitting down.
What does the trail of blood leaning into the dining room indicate?
It indicates that Mr. Barrett moved from the to the dining room while being shot.
Administrator, we are done with this document. Was there anything of importance on the body of the deceased?
Yes, there was a piece of paper under the deceased's right hand.
What did you do with this piece of paper?
I removed it and tagged it as evidence.
Your Honor, I would like the administrator to bring up the piece of paper that CM Cheney tagged as evidence.
The administrator may publish.
Your Honor, can you see the exhibit? Can you see the document?
Yes, thank you.
And Officer Cheney, can you see the document?
Yes.
What is this document?
It is an letter addressed to my dearest Tootsie.
Your Honor, I would like this document entered into evidence as exhibit number 2.
Any objections?
Objection, Your Honor.
Basis?
On the basis of relevance, we do not necessarily know that Barbara Barrett has even read the letter.
All right, sustained on lack of foundation.
After investigating the scene of the crime, did you make an arrest?
Yes, I took Mrs. Barrett into custody.
Who took Mrs. Barrett's statement when she arrived at the police station?
I did.
Did you read her rights?
I make it a habit to read witnesses their Miranda rights.
Did Mrs. Barrett sign her her confession?
Yes.
Did she indicate anything after signing it?
She indicated that it was true and correct.
Did Mrs. Barrett say that Mr. Barrett had threatened her before he was shot?
No, she specifically said that he had not.
Did you do any follow-up work on the case?
Yes, I wrote the police report the next day.
Did anyone approve this police report?
Yes, J.H. Holmes was the approving officer.
Thank you, Your Honor. No further questions for this witness, Your Honor.
All right, cross-examination.
I'd like to call Steve Cheney to the stand. Were you dispatched?
I'm sorry, counsel, you want to do what?
Call Steve Cheney to the stand.
He's already on the stand. Your cross-examination may commence.
Okay. Were you dispatched to the Glenmont area of Haddonfield when you got the report of a shooting?
Yes.
Was 9:50 p.m. the approximately time when you got the report of the shooting?
Yes.
Was Barbara Barrett in the downstairs bathroom when you entered the house?
Yes.
And did you read the Miranda warning to Barbara?
I have no specific recollection of reading her the Miranda rights.
Then, is it your responsibility as an officer on the scene to Mirandize Barbara Barrett?
Yes.
Okay. Did you accurately record the police report?
Yes.
Your Honor, the defense would like to ask the administrator to pull up the police report as exhibit number 2.
The administrator may publish.
Thank you, Administrator. Can the judge see the exhibit?
Yes, thank you.
Can CM Cheney see the exhibit?
Yes.
CM Cheney, can you please identify this document?
This document is my police report.
And is that your signature?
I cannot see the signature. Yes.
Your Honor, the defense would like to admit the police report as exhibit number 2 into evidence.
Any objections?
No, Your Honor.
Okay, seeing no objection, the court will admit.
On lines 7 and 8 of the police report, it details the date, time, relationship, and weapon used. Is that correct?
Yes.
On lines 7, and did you check the relationship as stranger to stranger?
Could you say that again?
Did you check the relationship was stranger to stranger?
No. Yes.
And Was Barbara married to John?
Yes.
So was it your job as an officer to accurately record the police report?
Yes.
Therefore, you did not accurately record the evidence. Administrator may remove the exhibit.
I'm sorry, the court did not hear the witness's answer to the last question.
So what? You did not accurately record the evidence.
Yes.
All right, thank you.
And then administrator, no further questions, Your Honor.
Anything else on redirect from the state?
Oh, Your Honor.
All right, the witness is excused and may mute your video conference. State's next witness.
Your Honor, I would like to call Joe R. May to the stand. What is your full professional title?
Joe R. May, MD.
What is your current occupation?
I am a practicing pathologist.
Your Honor, do I have permission to treat Joe R. May as an expert witness?
Any objection to the doctor's qualification as an expert?
No, Your Honor.
All right, he's tendered and accepted as an expert. You may proceed.
Thank you. Were you the examiner for the body of the deceased?
Yes, I was.
When did you examine the body?
The day after the shooting at approximately 3:30 p.m.
Who authorized this examination?
Coroner John Smith of Milton County.
What was the manner of the deceased's death?
Violent and brutal homicide.
What appeared to be the cause of the deceased's death?
A gunshot wound to the head.
Were there any pre-existing abnormalities that also could have caused the deceased's death?
No, there were no pre-existing abnormalities that I could find.
What were the injuries that you observed on the body of the deceased?
5 gunshot wounds to various places on the body of the deceased.
Your Honor, may the administrator please show the body diagram?
The administrator may publish.
Dr. May, can you tell us what this is?
This is the diagram of the body that I drew up.
Your Honor, the prosecution would like to submit the body diagram as Exhibit 3.
Any objection from the defense?
No, Your Honor.
All right, so admitted.
How many shots were fired at the deceased while he was facing the shooter?
1 in the upper portion of the left arm.
And how did you determine this?
When a bullet enters, the bullet hole is small and neat, but when it exits, the hole will be more blown out.
Did this gunshot wound have powder marks?
No, powder marks were absent.
How far away from the target does the gun have to be in order to avoid powder marks?
The muzzle of the gun must be at least 2 feet away to avoid powder marks.
Were any shots fired at the deceased while he was facing away from the shooter?
Yes, 1 to the head, 2 to the back, and 1 to the thigh.
What does the angle of the shot to the leg imply about the position of the shooter compared to the position of the deceased?
The angle of the shot to the leg implies that the shooter was sitting down while the deceased was standing.
Were any shots fired while the deceased was lying down?
Yes, 1 to the head and 2 to the back.
How can you determine that those 3 shots were fired while the deceased was on the floor?
The angle of the bullet's entry is 45 degrees, implying that the deceased was lying on the ground while the shooter was standing over him.
Thank you, Administrator. We are done with the diagram. Thank you, Your Honor. No further questions.
Cross-examination.
Did you perform a toxicology report on John Walker Barrett?
Please state the question again.
Did you perform a toxicology on John Walker Barrett?
I do not recall.
So it is entirely possible he may have been intoxicated that evening.
It is possible.
No further questions, Your Honor.
Anything on redirect?
No, Your Honor.
Okay, the witness is excused. Any other witnesses for the state?
The prosecution rests.
All right. Prior to the defense's case, will there be any motions made?
No, Your Honor.
All right, then the defense may commence with its case. You may call your first witness.
Your Honor, I would like to bring Barbara Barrett to the stand.
I'm Barbara Barrett.
Yes, thank you. Please state your age for the court.
47 years old.
Have you been in any previous marriages?
Yes.
How long were you married to your first husband?
6 years.
Do you have any children?
Yes, I have 2.
And these 2 children were from your previous marriage, correct?
Yes.
Were the children home at the time of the incident?
No, they weren't.
Where did you meet John?
I met him at an alumni function.
What was your first impression of him?
I thought he was charming and handsome.
How did you 2 interact that night?
Well, we talked for several hours about the case he just won, and we had both been drinking a lot that night, so we went outside to get some fresh air, and that's when he pushed me into the bushes and got fresh.
What did he do the next morning?
He called and apologized and sent a bunch of flowers to my house.
When did you 2 start dating?
Shortly after that.
How long were you dating him before he proposed?
6 months.
What did John do during a certain incident about 2 weeks before the wedding?
Well, he came over and I could tell he had been drinking a lot. My housekeeper made us some food and we sat down to eat, but he didn't want to eat. He told me to go fix him a drink, and I was trying to avoid a scene, so I made him a weak drink.
What happened when you offered him the drink?
Well, he didn't like that, and he threw it against the wall, and the glass shattered. And that's when he started yelling at me and calling me names. And he pushed me against the wall and slapped me, which surprised both of us, and we both started crying.
What promise did he make to you after that happened?
He said he would never hit me again.
When in your marriage did he start abusing you?
Shortly after he went back to work.
When the violence first started, you sought out help from a minister and several doctors. What did they advise and do to help you?
Well, the minister told me I needed to forgive my husband and submit myself to him. And one of the doctors asked me what I did to make him so mad.
How often would he beat you?
3 to 4 times a year.
One time when the beating was particularly bad and you had hit your head on the bathtub, what happened?
Well, I was unconscious for several hours, and by that time, Dawn had already left. I called the police, and they said there was nothing they could really do. And they called me several hours later just to see if I was still alive.
Did you ever catch John with another woman?
Yes. One time he phoned and said he was going to be home late, and around 12 o'clock I got worried, so I drove to his office, and that's when I saw him and a blonde on the couch, and then I went home.
What happened after you fled home?
Well, he didn't come home for several hours, and when he did, he was yelling and screaming at me, saying if I was a better wife, he wouldn't need to sleep around, and how I shouldn't be spying on him. And that's when I could tell he was going to beat me, so I tried to run, and then he hit me, and I fell to the ground, and he started kicking me, and I became unconscious.
A little while before the incident that you are on trial for today, he came to you suggesting that your marriage was in difficulty. Is that correct?
Yes.
When did he come home on the night of the incident?
He came home at 9.
Was that late for him?
Yes.
Was John sober that night?
Yes, for once.
What conversation did you two have while waiting for dinner?
I told him I was unhappy that he was coming home so late. He said that was none of my business and how he wanted a divorce, which surprised me because we've been through so much together.
When you were at the table eating, did he tell you to leave?
Yes, he did.
What did you do when he dismissed you?
I went to the living room and poured myself a glass of wine to calm my nerves because I've been crying so much.
When he came into the living room, what was he holding?
He was holding a belt in his hand.
What were you thinking at the time?
That's when I knew he was gonna kill me.
Do you remember anything after he approached you with the belt?
No.
Lastly, do you ever remember the police, CM Cheney, who took you into custody reading you your Miranda rights?
No, he never Mirandized me.
No further questions, Your Honor.
Cross-examination.
Your Honor, may the administrator bring up Barbara Barrett's confession?
Administrator may publish.
Your Honor, can you see the document?
Yes.
Mrs. Barrett, can you see the document?
Yes.
What is this document?
It's my confession.
And is that your signature at the bottom?
Yes.
Your Honor, the prosecution would like to enter Barbara Barrett's witness statement as Exhibit 4.
Any objection from defense?
No, Your Honor.
So admitted.
Mrs. Barrett, can you please read? Let's see. I'm sorry. May we now see the witness statement, please? And what is this document?
My witness statement.
And is your signature at the bottom?
I can't see it yet. Yes, that's my signature.
Thank you. May we, let's see. May we please see the full bottom page? Thank you. Mrs. Barrett, could you please read the highlighted sentence?
About 3 weeks before John's death, he came to me and said he thought our marriage was in difficulty. I knew he had. Do you want me to continue reading?
No, that is it. Thank you. Thank you, Administrator. We are done with the document. Mrs. Barrett, did you try to resolve this difficulty?
Yes.
Did John do anything in return, or was he working late?
No, he was working late.
Previously in your marriage, John had also worked late. Had he actually been working?
I'm sorry, I don't understand your question.
Previously in your marriage, John had also worked late. Had he actually been working or was there something else?
I suspected he was having an affair.
Did you ever confirm that theory?
Yes.
What happened when he came home after you caught him with that other woman?
Well, he didn't come home for several hours, and when he did, he was yelling and screaming at me. He said if I was a better wife, he wouldn't need to sleep around and how I shouldn't be spying on him. And that's when he started hitting me, and I became unconscious.
What did you tell the hospital staff when you were taken to the hospital after this incident?
That I fell down some stairs.
Was that actually what happened?
No.
So you lied to the hospital staff, correct?
Yes.
Moving on to the night in question, did your husband desire a divorce on the night of his death?
Yes.
Was Mr. Barrett sober on the night of his death?
Yes.
Your Honor, may we please see may we please see Barbara Barrett's witness statement?
Objection, Your Honor.
Basis?
There's not enough grounds for this since it was never formally entered as an exhibit.
All right. Is this being used as evidence or impeachment and refresh of recollection?
I'm going to use it as evidence.
All right. Objection sustained. It's not yet admitted to evidence.
Sorry. May we enter Barbara Barrett's witness statement into evidence?
It's moved. Any objection?
No, Your Honor.
It's admitted. You may proceed with the exhibit.
Thank you. All right. Could you please read the highlighted section?
When he was sober, he was the most considerate, sorry, I can't see it, considerate, sincere, and kind man I had ever known.
Who is the he in this sentence?
My husband, John.
Thank you. We are done with this document. Did your husband start to become verbally abusive about a week before his death?
Yes.
Did you realize that this was the beginning of another violent cycle?
No.
May we please see Barbara Barrett's witness statement again? May we see the second page, please? Thank you. Please read this selected spot.
I know this was the beginning of another violent cycle.
Thank you. We are done with the document. . In the week before he died, did Mr. Barrett ever try to kill you?
Yes.
On that particular night, was Mr. Barrett sober?
I don't recall.
May we see the witness statement again? Barbara Barrett's witness statement. And the second page, please. Please read this spot.
I knew he was trying to kill me.
Thank you. We are done with the document. Did you actually think you would die when he was trying to kill you?
During what incident?
During the week before he died.
No.
Why then would you think he was going to kill you on the night of his death?
He had a look in his eyes.
Objection, Your Honor. The defense has created a material fact.
Okay. If you'd like to point out, I assume you're referring to the last answer of the defense. Is there a stipulated fact that's directly contradicted by that statement?
It is never in her witness statement or her confession, and it gives them a significant advantage.
Objection, Your Honor.
All right. Response?
My response to this objection is that it is actually true that she said that he had a look in his eyes when he came towards her with the belt.
All right. And can you refer to the record where that's contained?
Yes. May I please see Barbara's witness statement? Okay. Thank you. Now, one second. It appears I am mistaken. Never mind.
Okay. The jury will disregard the last answer. You may proceed.
Did your husband ever actually choke you with his belt?
No.
Is it true that your witness statement says Mr. Barrett entered the living room with a belt, but your confession never says anything about a belt?
Yes, that's true.
Does your confession say you were read and understand your rights, but your witness statement says you never knew what your rights were?
That's true.
When was your statement taken?
I don't recall. I believe after the incident.
May we see a little bit lower on the witness statement, please?
January 1st, 1990.
Actually.
Or do you mean January 19th, or I mean not 19th, 17th, 1989?
Thank you. Does this sound like it would, let's see. Your first interview with Dana McGuire was 2 weeks after the incident, correct?
Yes.
And the 17th of January would be approximately 2 weeks after that, correct?
Yes.
Thank you, Your Honor. No further questions.
Anything on redirect? Defense counsel, any further questions on redirect?
No, Your Honor.
All right, the witness is excused. You may proceed with the next defense witness.
Your Honor, I would like to call Dana McGuire up to the stand. Please state your name and age for the court.
My name is Dana McGuire and I'm 42 years old.
One quick request. Could the administrator please take down the previous document we are using? Thank you. What is your profession?
I'm a practicing psychologist.
I'd ask the witness to get a little closer to the mic, please.
Where did you get your education and what qualifications did you earn there?
I received my BA from Campbell State University, Haddonfield, South Carolina.
Do you have previous experience of being an expert witness in court?
Yes, I've appeared in court several times.
Your Honor, I would like to have Dana McGuire recognized as an expert witness.
Any objection from the state?
No, Your Honor.
So moved, accepted, and qualified as an expert. You may proceed.
Your Honor, I would like to have Dana McGuire's witness statement admitted as evidence. 5, Exhibit 5.
Is this the witness's own written statement?
Yes.
Okay, any objection from the state?
No, Your Honor.
Based on a lack of objection, the court will admit.
Thank you, Your Honor. It says in your statement that you wrote a book. What was it about?
My book was called Living in Hell, The Life of a Battered Woman, a pretty self-explanatory title.
How much do you charge per private counseling sessions per hour?
I charge $75 an hour.
How much do you charge for appearing in court by the hour?
I charge $150 an hour.
What research have you conducted on the topic of battered women?
I've collected over 500 fragments of stories from such women.
Please tell us about the experiments conducted by Dr. Samuel Michaels that you wrote about in your statement, and how this explains why women often endure this type of abuse instead of leaving their husband.
The experiment conducted by Dr. Samuel Michaels consists of dogs, which were placed in cages and had random electronic shocks that weren't too strong to kill them, but strong enough to hurt them. Eventually, they ceased all voluntary movement and didn't even try to leave when they were dragged out. This happens the same to battered women because of similar instances.
What qualifies a woman as a battered woman?
A battered woman is one who is subjected to any physical or psychological abuse against her own will.
And what qualifies a couple as a battering couple?
A battering couple must go through 2 battering cycles to be qualified.
Please describe and explain how a battering cycle works.
A battering cycle is split into 3 phases. The first phase, the initial battering phase, is one of great tension mounts and small battering instances. The second phase, the acute battering phase, is one where the husband unleashes huge amounts of tension and there is major battering instances. The third phase is the loving phase, which is much comparison to the honeymoon.
Can you tell us about your theory of learned helplessness?
The theory of learned helplessness happens when a woman loses her grasp on being an independent person.
Is it true that oftentimes battered women disassociate violence leading to death or serious bodily injury?
Yes, one woman that I interviewed said that the bullet wounds in her husband's head would recover because they weren't so severe.
Was Barbara Barrett thinking in her right mind during the incident?
No.
Do you believe that Barbara had intent to seriously harm or kill John Barrett when she had acted?
No.
Could Barbara have controlled her actions at all that night?
No, she could no more control her actions than she could the rising sun.
No further questions, Your Honor.
All right. Cross-examination.
May the administrator take down the document. You use animals to prove your theory on learned helplessness, correct?
I don't know.
Your Honor, may the administrator bring up Dana McGuire's witness statement? May I see the bottom page? Sorry, the middle page. Can you read the highlighted portion?
It's kind of hard for me to read. Can you zoom in?
Can you read the highlighted portion?
This theory was first recognized several years ago as a result of experiments by Dr. Samuel Michaels in his studies of early response reinforcement. He had his assistants place dogs in cages.
Thank you. So is it true that you use animals in your theory about learned helplessness?
I don't personally.
Is your theory first recognized by results by experiments used on animals?
Yes.
Are animals exactly the same as humans?
No.
How long after the shooting was your first interview with Barbara Barrett?
About 2 weeks after.
Administrator, you may remove the document. If your theory is true, Mrs. Barrett should act passively toward Mr. Barrett, correct?
Correct.
Was Mrs. Barrett passive toward Mr. Barrett on the night of his death?
No.
You earlier testified about that there are cycles in your theory. Can you restate those cycles?
In which way?
Can you tell us what they are?
The battering cycle is split into 3 phases. The first phase is the initial phase where tension mounts and there are minor battering instances. The second phase is the acute battering phase where there are major battering instances and the husband unleashes mounts of tension. And the final phase is the loving phase, which is easily compared to the honeymoon.
If tensions were rising in their Barrett's household, is it possible that Mrs. Barrett could have suspected that an acute battering phase would occur shortly?
Yes.
In your witness statement, you say that Mrs. Barrett saw Mr. Barrett as someone who betrayed her, yes?
Could you repeat the question?
In your witness statement, you say that Mrs. Barrett saw Mr. Barrett as someone who betrayed her.
Yes.
You also state that Mrs. Barrett had been building up fury against Mr. Barrett for years.
Yes.
Do you think the situation outlined in Mrs. Barrett's statement aligns perfectly with your theory?
Yes.
If your theory is true, battered women don't think there will ever be death or severe injury to themselves or the husbands?
Yes.
If this is true, how can Mrs. Barrett see Mr. Barrett as someone capable of causing her serious injury or death?
Could you repeat the question?
If this is true, how can Mr. Barrett see Mrs. Barrett as someone capable of causing her serious injury or death?
I don't understand.
If your theory is true, Mrs. Barrett, how can Mrs. Barrett see Mr. Barrett as someone capable of causing her serious injury or death?
I don't know.
I see. We have no further questions for this witness.
All right, anything else on redirect? Defense counsel, any further questions? Witness is excused. Does defense have any further witnesses?
No, Your Honor.
I'm sorry, is that a no?
Yes, Your Honor.
Okay. Is defense resting?
The defense rests, Your Honor.
Okay. Does the city have anything in rebuttal?
No, Your Honor.
All right. Ladies and gentlemen of the jury, the evidence is closed. We're going to turn now to the closing arguments of the parties. As is typical in all cases, the prosecutor goes first, defense counsel then proceeds, and then the prosecutor gets a short rebuttal. When the prosecutor is ready, you may commence your closing argument.
May it please the court. Your Honor, my name is Jay Consier and I'll be making the closing remarks in this case. Murder is wrong. This case is important because we must keep it that way. On December 18th, Mr. Barrett was killed by Mrs. Barrett. On that night, Mr. Barrett came home late, but sober, which means, according to Mrs. Barrett, that he was the most considerate, sincere, and kind man. He told his wife that he wanted a divorce. They argued and then had dinner while arguing some more. Mrs. Barrett was told to leave the dining room. The next time that they were seen, Mr. Barrett was bloody and being chased by Mrs. Barrett, who was holding a gun. Several minutes later, Mr. Barrett was lying dead in the dining room, and Mrs. Barrett had locked herself in the bathroom. Mrs. Barrett committed murder when she killed Mr. Barrett. Mrs. Barrett premeditated the shooting of Mr. Barrett by practicing with a gun earlier in the day before she murdered him. Mrs. Barrett was also complaining about the fact that Mr. Barrett was always late from work. Previously, when Mr. Barrett was late from work, he was actually having an affair. Arguably, Mrs. Barrett suspected that he was actually having an affair now as well. On the night of the killing, Lee Porter heard Mrs. Barrett say something like, "You'll be sorry," as Mrs. Barrett was sent out of the dining room. Additionally, Lee Porter has testified that she saw Mrs. Barrett chasing Mr. Barrett with a gun, which shows that she shot and pursued him. This also proves intent because a person who feels threatened will run away and not chase their attacker. And as it is obvious that she is not chasing him out of self-defense, it is probable that she is chasing him out of malice. As we heard from Dr. May, Mr. Barrett was only shot once while he was facing Mrs. Barrett. He was shot again while he was not facing Mrs. Barrett, and he was shot 3 times while he was on the floor, one of those shots killing him. The compelling evidence that C.M. Chaney found at the scene of the crime led him to deduce that Mrs. Barrett was the killer. After all, is there more compelling evidence than the suspect screaming that she didn't mean to commit the crime? Mrs. Barrett has only one witness defending her, Dana McGuire, who she first met 2 weeks before Mrs. Barrett's statement was taken. This gave Mrs. Barrett a significant amount of time to learn McGuire's theory and to mold her story to help her case. One thing that supports this is the fact that although Mrs. Barrett's confession never mentions the belt, her witness statement makes that her main defense. One would think that the cause of her fear would be prominent enough to make her confession. Additionally, Mrs. Barrett told C.M. Chaney that she was not threatened by her husband before he was shot. In Mrs. Barrett's witness statement, she mentions the fact that she knew it was the beginning of another violent cycle. This points to premeditation. We can show that she has been known to lie because she lied to the hospital staff. If she was willing to lie then with the purpose of protecting herself, why should she not be deceptive now? From these facts, we find that Mrs. Barrett is capable of lying to authorities. She premeditated her killing of Mr. Barrett, and she was intent upon wrongfully shooting him. For killing her husband with malice forethought, we would like Mrs. Barrett to be found guilty of murder and sentenced to jail for an appropriate amount of time. Murder is wrong.
All right. Closing argument for the defense.
Ladies and gentlemen of the jury, today we have heard from Dana McGuire, Officer Cheney, Joe R. May, Lee Porter, and Barbara Barrett. From Barbara, we have heard that a few weeks before the date of her wedding with John, John struck her across the face. John then vowed to never hit her again. Barbara states that John has beaten her multiple times since, one beating even causing her to lose consciousness. From Lee Porter, we have heard that the Barretts argued often, and on one occasion after an argument, Lee heard Barbara scream. John promised to never hurt Barbara again, and for this reason, Barbara proceeded with the wedding. But John lied. On the night of the incident, before dinner, John claimed he wanted a divorce. At dinner, Barbara was crying, and trying to calm down, she left the room where John followed with his belt in his hands. Barbara was obviously scared for her life. Murder is killing with malice, but we see that Barbara was trying to defend herself. Ladies and gentlemen of the jury, I implore you to find the only verdict possible. Barbara Barrett is not guilty of murder. She was simply trying to protect her life.
Any rebuttal from the prosecution?
We will make no further remarks.
All right. That completes the case. The court is going to take a brief recess, allow the jurors to fill out their marks and comments, as well as the court, and take a brief restroom break.
Thank you, Your Honor. Yes, at this time, teams, you will be allocated to your breakout rooms where you can shake off some of your nerves, prepare for your next role in the next round, and as the judge recommended, use the restroom, have snacks, cig of water, whatever it is that you need to do. Thank you.
Hey all, I think I mostly have it down to North Bend and Issaquah. if anybody is Kent Kirkland and has their name as a witness, let me know so that I can send you over to the Kent Kirkland.
Oh, yikes.
Welcome back, everyone. I see that Judge Geip is with me, and I see my attorneys and witnesses are returning back to their cameras. I just want to share a little quote. One of my favorite books is To Kill a Mockingbird, and there's so much hardship in that book, and there's so much courage and goodness in that book. And so one of the quotes I wanted to share with you is from Atticus Finch, and he says, "You never really understand a person until you consider things from his point of view, until you climb into his skin and walk around in it." And one of the things I love about that quote is that's true. We have our conceptions of what we think things are, and we have these ideas. And as homeschooling Christian mamas, biblical worldview comes into play. And we really want to be above reproach. And when we take someone into consideration, we don't want to just look at circumstances, but we want to take that person as a whole person into consideration and their feelings. And I love that we get to do that through this mock trial. That's what I really think comes alive in the mock trial is when the students are assigned roles. They've all been studying, right? Knowing the notebook. But when they get their roles assigned, they get to walk around in that skin. And that's exactly what our students have been doing. And so I appreciate this first round. It's been fun to see you guys all working together. I've seen bits and pieces, and it's been fun to see some of the nerves shake out and the misconceptions or thoughts or ideas maybe you thought away that somebody was going to ask you a question and maybe they didn't. And so it's been fun to kind of walk through that with you guys. Right now, what I'll do is I'll start to reconvene the courts in just a moment with Judge Geip and walk through, because this is now round 2. So we're switching sides, so to speak. All the exhibits, I would like to remind participants, have been wiped clean. So when you need to call an exhibit into order, you need to follow the protocol that's been laid out for you. You refer to it. Make sure that you're careful of titles of exhibits and that you're numbering them properly and titling them properly as well. Let's see, any other notes? Oh, just a few more of the protocols. Watch your microphones, watch your muting. I know a few of us have feedback, like I know my computer's probably giving you some feedback right now, and I apologize for that. But try to watch any of that background noise. And again, just model integrity by working above reproach with no coaching from parents, but that your parents are just proctoring by your side. And we hope everyone is enjoying their time with us today. So Judge Geip, the Superior Court of Milton County is now in session. The Honorable Geip presiding. God save the state and this honorable court.
Okay. Good afternoon, everyone. We're ready to proceed in this trial. Will the counsel and witnesses for the prosecution please identify themselves?
Good afternoon, Your Honor. My name is Rachel Arnold, and I will be doing the opening statement and the cross-examination of Dana McGuire. And my co-counsel and the witnesses introduce themselves?
Yes.
Good afternoon, Your Honor. My name is Christopher Bond, and I will be direct examining CM Cheney and Lee Porter.
Good afternoon, Your Honor. My name is Trinity Divini, and I will be direct examining Joe Arme and cross-examining Barbara Barrett.
The witnesses for the prosecution?
Good afternoon, Your Honor. My name is Rick Liskey, and I am the CM Cheney.
All right.
Good afternoon, Your Honor. My name is Joe Arme, and
the person playing Joe May, what's your name?
my name is Ethan.
Okay.
Good afternoon, Your Honor. My name is Natalie Schubert, and I will be playing Lee Porter.
All right. Counsel and witnesses for the defense, if you'll identify yourself.
Good afternoon, Your Honor. My name is Ava Corey, and I will be doing the opening statement, direct examination of Dr. Dana McGuire, and the cross-exam of Officer C.M. Cheney. May my co-counsels and witnesses introduce themselves?
Of course.
Good afternoon, Your Honor. My name is Grant Fuller, and I will be doing the closing statement, the direct examination of Barbara Barrett, and the cross-examination of Joe R. May.
You're muted.
I'm sorry. Good morning, Your Honor. My name is Ashlyn Anderson, and I will be doing the cross-examination of Lee Porter.
All right. And the witnesses?
Good afternoon, Your Honor. My name is Ariella Johnson, and I'll be playing Barbara Barrett.
Good afternoon, Your Honor. My name is Genevieve Zaylor, and I will be playing Dana McGuire.
All right. Are the parties prepared to proceed?
Yes, Your Honor.
And for the state?
Yes, Your Honor.
Okay. Any pretrial motions?
No, Your Honor.
No, Your Honor.
Okay. We'll commence with opening statement. The state may commence with its opening statement to the jurors.
Yes, Your Honor. On the night of December 18th, 1988, John Walker Barrett left his attorney's office for the last time. Mr. Barrett was an average man, a lawyer, a stepfather, a husband. When he drove home, he didn't suspect the events that occurred later that night. Upon his arrival, he was greeted by his wife, Barbara Allen Barrett, in distress and disarray. She was greatly vexed by his annual late arrivals at home. After a few harsh words over the dinner table, Mrs. Barrett proceeded to the living room for a glass of wine. Before long, her husband lay dead on the kitchen floor. Ladies and gentlemen of the jury, our witnesses, C.M. Cheney, Lee Porter, and Joe R. May, will prove that beyond the shadow of a doubt that Mrs. Barrett deliberately shot and killed her husband in a homicide of first-degree murder.
Opening statement by defense.
Thank you, Your Honor. This case is about a battered and abused woman who was repeatedly and violently beaten. The defendant, Mrs. Barrett, was beaten by her husband, sometimes so violently that it would leave injuries that wouldn't allow her to leave her home for several days. On the night of December 18th, 1988, Mr. Barrett told Mrs. Barrett that he could no longer live with her and wanted a divorce. He later entered the living room carrying a belt, the very thing which he had used to violently beat her with in the past. Already distraught by his changed behavior toward her, seeing the belt in his hand triggered something in Mrs. Barrett's mind, sending her into mental distress. The prosecution has claimed that my client killed Mr. Barrett. However, my client is a victim of violent and physical abuse and was forced to act out of self-defense with no malice aforethought or any intent. The prosecution relies on the confession that Officer C.M. Cheney took from Mrs. Barrett just moments after the incident to tell them what really happened. Mrs. Barrett, confused and distressed, could not remember anything after her husband entered, belt in hand. The prosecution also fails to prove without doubt that Officer Cheney read Mrs. Barrett her Miranda rights, confusing and upsetting the witness even more. The prosecution also relies on the Barrett's housekeeper, Lee Porter. Miss Porter claims to have seen what had happened on the night. However, Miss Porter's claims are contradicted by her admission to only hearing loud noises. Miss Porter was also convicted of stealing $100. She said she didn't do it, yet she pled guilty. We would ask today that you find the defendant is not guilty of murder. The prosecution has not met its burden of proof, and we ask for a verdict of not guilty. Thank you.
Thank you, counsel. The state may commence with its first witness. A reminder, everyone testifying is under oath as previously sworn. You may proceed.
Your Honor, I would like to call CM Cheney to the stand. Where did you receive your education?
I received my education at South Bend College, Haddonfield, South Carolina.
What jobs did you have before becoming an officer?
In my off hours, I was a security guard at First Bank and Trust.
How long have you been a police officer?
For 6 years.
When did you arrive at the scene of the crime?
At approximately 9:57 p.m.
Where was the defendant when you came there?
The defendant was in the downstairs bathroom.
Did Barbara Barrett resist arrest in any way?
She went open the door, so when we told her that we had to break down the door, she came out crying.
Did you find any evidence pertaining to alcohol?
On the table near sofa 1 was a glass of scotch, and on the table next to sofa 2 was a glass of wine, half-drunken wine with a lipstick mark on it.
And was there anything near the deceased when you initially found him?
Near him was a gun and a letter.
Your Honor, I would like to ask the administrator to bring up the diagram of the house for prosecution exhibit number 1.
May be published.
You can see the exhibit, Can you see the exhibit, Your Honor?
Yes.
Can you see the exhibit, CM Cheney?
Yes.
As you can see, Your Honor, there are blood stains that lead towards that lead from the living room towards the breakfast room, with the gun and letter being found near the deceased in his hand, near the deceased's hand. That is all, Your Honor. No further questions.
Cross-examination.
Officer Cheney, you said in your witness statement that you were riding alone on the night of December 18th, 1988. Is that correct?
Yes.
Oh, Administrator, you may please remove the exhibit. You also stated that you have a second form of employment.
Yes.
It is true then that you work 2 jobs.
Yes.
You also have 2 young children at home, correct?
Yes.
Thank you, Officer Cheney. Back to the night of the incident. You received a dispatch call to the scene of a shooting at 2437 Rambling Woods Drive, correct?
Yes.
You were met at the scene by the housekeeper, Lee Porter.
Yes.
You say that she was crying hysterically.
I don't recall.
After investigating the scene, you then went to locate Barbara Barrett, did you not?
Yes.
You then found her locked in the downstairs bathroom.
Yes.
And at that time, Officer Cheney, you threatened a distressed woman with breaking down the door to get her out, didn't you?
Yes.
Upon opening the door, the stress of the situation overpowered her and she passed out, correct?
Yes.
You had to call a doctor to attend to her, didn't you?
Yes.
It took several minutes to revive her, correct?
Yes.
Moments after she was revived, you led her to the kitchen table, right?
Yes.
Your Honor, I would like to refer to Exhibit 1.
You may publish. Have you moved to admit or just publish?
Just admit it has already been, the diagram of the house has already been admitted into evidence, so just publish. Your Honor, can you see the exhibit?
I have, but the diagram was previously published, but it has not been admitted into evidence.
Oh, Your Honor, I would like to admit the diagram of the house into Exhibit 1.
Any objection from the state?
No, Your Honor.
Admitted.
Officer Cheney, does the path highlighted on the diagram accurately show how you would have gotten Mrs. Barrett from the bathroom to the kitchen?
Yes.
You led a distressed and hysterical woman past her deceased husband on the way to the kitchen?
Yes.
Thank you, Administrator. You may remove the exhibit. Officer Cheney, did you give a statement?
Yes.
Your Honor, the defense would like to admit Officer Cheney's statement as Exhibit 2.
Any objection? Any objection from the city?
No, Your Honor.
All right. Based on a lack of objection, admitted.
Thank you, Your Honor.
You may proceed with your questioning.
Officer Cheney, can you please read this highlighted section for the court? Oops.
I would only like to add to the report.
I'm sorry, Officer Cheney. Can you read this section for the court?
I have no specific recollection of reading her Miranda warnings.
You do not recall reading her warnings, correct?
Yes.
Thank you, Administrator. You may remove the exhibit. Thank you, Officer Cheney. Now let's take a look at the evidence that you obtained from the scene. In your report, you clearly state the pager, which I tagged as evidence, was found crumpled in his right hand, correct?
Yes.
In the same report's property summary, however, you have 1, bloodstained letter from the victim, correct? You mistakenly referred to the letter as a pager then, correct?
I don't recall.
Thank you, Officer Cheney. Moving from the scene of the incident to the police station. Upon arriving at the station, still not having been read her rights, you obtained a statement from Mrs. Barrett.
Yes.
It was after she signed the statement that you allowed her to call her attorney, correct?
Yes.
You both questioned and obtained a statement from Mrs. Barrett prior to her contacting her attorney?
Yes.
Thank you, Your Honor. No further questions.
Anything on redirect?
No, Your Honor.
The witness is excused. State's next witness.
Your Honor, I would like to bring Joe Armay up to the stand.
You may proceed.
Jessica Besso. So that's our juror because we were considering having the jurors' names as well. So she's North Bend.
Please state your name for the court.
My name is Joe Armay.
What is your profession?
My profession is as a medical examiner.
Who is the deceased you examined?
The body of John Walker Barrett.
Your Honor, I would like to have the diagram of the body entered in as Exhibit 3.
Any objection?
No, Your Honor.
Admitted. You may proceed.
Besides the bullet wounds, was John's body healthy?
Yes.
How many bullet wounds did John Barrett have?
5.
Please describe the placement of each bullet wound.
One was shot to his left arm, the other was shot to his right leg, and then the other 2 were shot to the spine, and then the last one was shot to the back of the head.
Which bullet was the cause of death?
The one shot to the back of the head.
It says in your autopsy report that 2 of the bullets in his back were fired into the deceased from an angle of 45 degrees. This means that John Barrett was shot twice in the back while laying face down on the floor. Is that correct?
Yes.
Were there any powder marks on his body?
No.
What does no powder marks on his body mean?
The person who killed John Barrett was standing at least 2 feet away.
Thank you. No further questions, Your Honor.
Cross-examination.
There were a total of 5 shots fired, correct?
Yes.
It is impossible to determine in what order the shots were fired, correct?
Yes.
Based off of a 45-degree angle, it is possible that the deceased was standing and the shooter was laying down on the ground. True?
True.
Thank you, Your Honor. No further questions.
Any redirect?
No, Your Honor.
All right, the witness is excused. Prosecution's next witness.
Your Honor, I would like to call Lee Porter to the stand. How long have you been working for the Barretts?
I have been working for the Barretts for 6 months.
Did anything peculiar happen earlier on the day of the murder?
Earlier during the day, I thought I heard a noise like a car backfiring. I went to go check it out and saw Mrs. Barrett coming through a door she never uses holding a gun.
How did the victim appear when he came home that day?
John was calm and sober when he got home.
Was there any sort of tension between them?
At dinner, they appeared to have had an argument right before, so when I was serving dinner, they were both mad and upset.
Did anything happen during dinner?
Mr. Barrett was saying something like, "I've had it with you, Barbara. Now you know I'm leaving tonight." Mrs. Barrett was crying and saying, "You can't do this to me." And because Barbara was crying, John asked her to leave.
And what happened between Mr. and Mrs. Barrett?
As Mrs. Barrett left, I heard her say something like, "You'll be sorry for this." I couldn't be too sure because I was walking into the kitchen then. The next thing I knew, I heard 3 loud noises like a car backfiring. I went to go see what had happened, and I saw Mr. Barrett limping into the dining room, bloody and clutching a piece of paper in his hand. After that, I ran.
No further questions.
Cross-examination.
Hello. Hello, Miss Porter. You are the housekeeper for the Barretts and have been for only 6 months, correct?
Yes.
Your typical hours are 2 p.m. till 10 p.m. Is that correct?
Yes, that's correct.
Did you give a statement?
Yes.
Can the administrator please close the statement for the diagram of the body and pull up Miss Porter's witness statement? Thank you. This is your statement, correct?
Yes.
And is that your signature at the bottom?
It is.
If it is okay with the judge, I would like this statement entered into evidence.
Any objection from the prosecution?
No, Your Honor.
All right, seeing no objection, the court will admit.
Thank you. Can you please scroll down on the witness statement? Thank you. Ms. Porter, can you please read Sorry, give me a minute. Sorry. Would the attorney please scroll out? Sorry, zoom out. Would that be okay? Thank you. Can you please read the sixth paragraph, the sentence going on the day of the shooting, sorry. Could you please read the sixth paragraph for the sentence starting the day of the shooting?
The day of the shooting, I heard noises just like a car backfiring coming from the backyard. They sounded just like the noises that sorry, was that all?
Yeah, that was all, thank you. Is it possible that it could have just been a car backfiring?
Yes, that's possible.
Thank you. You can put away the witness statement if that's okay. Thank you. Mr. Barrett had a bad temper, correct?
Yes.
Is it true that he would throw his silverware?
Yeah.
The Barretts would sometimes argue, wouldn't they?
Yes, they did sometimes.
You heard Mrs. Barrett scream one time after an argument, like she was being assaulted. Is that correct?
That's correct.
Mr. Barrett was saying things that night that implied that she loved him and would never want to hurt him. Is that correct?
Yes.
You said you heard Mrs. Barrett say, "You'll be sorry." Are you absolutely certain that she said that?
No, I'm not.
You left before the incident was over. Is that correct?
Yes.
Sorry, would you pull up the document again, please, Administrator? Would you mind reading the last sentence of your witness statement, Ms. Porter?
The judge put me on probation and that was that.
Sorry, I meant the last paragraph.
Okay.
Thank you, though.
I guess I should say that I've hardly been in trouble with the law. Only once did I get arrested back in 1979 because some lady I worked for said I took $100 from her purse. I never did, though. The judge put me on probation and that was that.
Okay, thank you, Administrator. You can close the witness statement now. You pled guilty for stealing the $100. Is that correct?
Yes.
Mrs. Barrett was in hysterics after the incident. Is that correct?
Yes.
She was screaming and locked in the bathroom. Is that correct?
That's correct.
Did you ever see Mrs. Barrett actually shoot the gun?
No.
Okay, thank you. That's all the questions that the defendant have for the
Can
witness.
you redirect for the witness from the state?
No, Your Honor.
All right, the witness is excused. Any further witnesses for the state?
The prosecution rests.
All right. Counsel for defense, you may call your first witness.
Thank you, Your Honor. I would like to call Barbara Barrett to the stand. Please state your name and age.
I am Barbara Allen Barrett and I'm 47 years old.
Where do you live and how long have you lived there for?
I live at 2437 Rambling Woods Drive, Haddonfield, South Carolina. I've lived there since 1964.
Do you have any children?
Yes, I have 2 children, Catherine Barrett, and Todd Michael Barrett.
How long have you known Mr. Barrett?
I knew John for approximately 10 years.
Where did you meet Mr. Barrett?
I met John in 1978 at an alumni function for Vassar.
How much time did you spend together at the function?
We talked for over an hour. I thought he was so charming and charismatic. I was also intrigued by his manners and his intensity.
What occurred after you were finished talking?
We went to the pool area to get some fresh air.
Did anything happen while you were out there?
While we were still in the pool area, John pushed me into the flower beds and started getting fresh. I also remember the wild look in his eyes.
Did you approve of what he was doing?
I was unhappy with it and managed to get up and leave without creating a scene. I immediately returned home.
What did he do about his actions?
John phoned several times to apologize and then flooded my house with flowers.
Did you begin dating him after this?
Yes, we saw each other every single day for 6 months.
How did he treat you during this time?
John was a wonderful companion most of the time, and he spent a lot of time with my 2 children who adored him.
What makes you say most of the time?
Well, John would drink, and when he drank, he would become extremely angry and often leave abruptly. I never knew what provoked him.
What would happen when he became angry?
He would beat me ruthlessly.
Can you please give us an example of when this would happen?
There was one time 2 weeks before the wedding.
What led up to this battering?
Well, John came over to my house and asked me to fix him chivas with water. I fixed a wink drink on purpose, hoping to avoid a scene.
What was his reaction to this?
He grew furious and threw the glass against the wall. There was broken glass everywhere. He then started insulting me, yelling I was incompetent, stupid, and condescending. When I tried to defend myself, he grew angrier, and finally he slammed me against the wall with great force and slapped me in the face.
What were your emotions to what had just occurred?
We both started crying and were surprised that this had happened.
Did this change your decision to marry him?
No, as quickly as John got mad, he became the compassionate and loving person I adored. He swore he would never touch me with violence again, and we continued with our wedding.
How were your lives for several weeks after the wedding?
For several weeks after the wedding, our lives were calm. We spent most of our time together, and he made me feel like a very special woman.
Then what happened?
John suddenly went back to work, although we did not need income, and there was times I didn't see him for days.
What occurred about 8 months after your wedding?
John phoned to say he was going to be late, and at midnight I became concerned and drove down to his office to check on him.
What did you see at his office?
I saw John sitting on the couch with another woman.
How did you react to this?
I ran out of the room as fast as possible and returned home.
And how did he respond?
When John came home, his face was red and contorted. He accused me of spying on him and humiliating him. I could tell he intended to beat me again.
What do you remember after that?
Well, John began hitting me with his fist in my face, and when I fell, he began to kick me. The next thing I knew, I was headed to a hospital in an ambulance, and John was gone.
What did you tell the people at the hospital had happened?
I told them I had fallen down some stairs. I wanted to protect John.
What did John do about his actions that night?
John phoned me every hour and then filled my room with flowers. He begged me to take him back and promised there'd be no more women or beatings in his life.
How was your marriage in the years following?
Our marriage was rocky and seemed to run in cycles.
Please explain what you mean by that.
Well, one day John would beat me with brutal force, and the next he would love me as if I was completely perfect.
How would he show his love?
Several occasions he told me he could not live without me, and I felt the same way about him. He was also very sensitive and compassionate at times.
What was the frequency of these beatings?
I was beaten or abused 3 to 4 times a year, sometimes so severely I couldn't leave the house for days.
Who all knew about the beatings?
I did talk to my minister and several doctors about the violence. I even called the police once.
What did your minister tell you?
My minister told me to be submissive and forgiving.
Did the doctors help?
The doctors only gave me tranquilizers to help me cope.
What about the police? Did they do anything for you?
Well, when I had called the police, John had already left because I had been unconscious for several hours. They did eventually call back to see if I was alive, but other than that, they did not do much.
What happened about 3 weeks before the day of John's death?
Well, 3 weeks before John's death, he came to me and said he thought our marriage was in difficulty.
What did you do?
Well, I knew John had been working long hours, so I said I'd give up my fundraising activities for the symphony so that we could try again.
How did he respond to this?
I thought he had agreed because for a few days, things seemed less tense.
You said a few days. What occurred after this?
Well, John suddenly became very sloppy in his personal habits, and our housekeeper, Lee Porter, was constantly picking up after him. He was also very tense and edgy and became verbally abusive again. I knew that another violent cycle was beginning.
What happened a few days later?
John came home, and while we were in the bedroom, he began to beat me with his belt.
What did he attack you with?
His belt.
What was his objective in doing this?
I knew he was trying to kill me.
I'm sorry, but now we have to talk about the night of your husband's death. What happened when your husband arrived home that night?
John came home around 9 o'clock. We went into the living room, and I told him how I was upset that he was continually coming home so late.
What did he think about this?
He said it was none of my business when he came home and that he wanted a divorce.
How did you respond to him?
I told him I didn't believe him and that I wanted him to think about it because I really couldn't live without him. We were both very upset.
What happened at dinner that night?
Well, I remember we were still arguing, and John said he was leaving that night. I guess I was crying a lot, and John told me to leave the room.
What did John do after you left the room?
He came into the living room where I was with the belt in his hand, and I thought he was going to choke and kill me.
What do you remember after that?
I don't remember anything else until the police came.
Now, moving from your house to the police station. What happened at the police station?
The officer there asked if I'd like to give a statement.
Did you give a statement?
I did.
Why did you give a statement?
I was so confused and upset that I gave a statement.
Did he ever tell you you could speak to a lawyer?
No, not until after I gave a statement.
When did you give your statement?
I gave my statement December 18, 1988 and January 17, 1989.
Were you ever asked to give a confession?
No,
Were you ever asked to sign a confession?
I was not.
Are you aware that you gave and signed a confession on the night of December 18th, 1988?
I am not.
What did the officer call the document that you signed that night?
He asked if I'd like to give a statement.
Did he ever read you your Miranda warnings?
At no time did he ever tell me what my legal rights were.
Did you ever speak to a lawyer?
After I gave a statement, I did call my lawyer.
What did your lawyer tell you?
My lawyer told me not to talk to the police until she could get there.
Would you have talked to the police if you knew you didn't have to?
No, I would never have talked to the police if I knew I didn't have to.
Thank you. No further questions, Your Honor.
Cross-examination.
Is it true that you inherited a large sum of money due to trust funds your father had?
Yes.
Your Honor, I would like to enter Dana McGuire's witness statement into evidence.
Dana McGuire is defense counsel's expert witness, is that correct?
Yes.
Okay. Basis for the request to enter the statement prior to Ms. McGuire's testimony?
I'd like to use it to back up one of my questions.
Okay, ask your question first, and then the court can decide on the admissibility of that document.
According to Dana McGuire, most battered women stay in a relationship because they need financial help. However, seeing as you are independently wealthy, doesn't that mean that you did not need any other financial aid?
That is not contained in my witness statement.
Is it true that you actually, sorry, could the administrator please take down the document? Is it true that you had a previous husband whom you've got a divorce with?
That is true.
It has been established that Lee Porter, on the day of the shooting, saw you walk in through a private door that you never used, holding a gun. Is this true?
That is not contained in my witness statement.
In your statement, it says on the night of the incident, John came home late. Did that upset you?
Yes, I was upset that he was continually coming home so late.
Was John sober on the night of the incident?
He was.
Did John say that he wanted a divorce once he got there?
He did.
Were you confused about the fact that he wanted a divorce?
I was upset.
At the dinner table, John told you to leave the room. Was that because you were very distraught?
I think he asked me to leave because I was crying a lot.
In your statement, it says that after John approached you with the belt, you don't remember anything. Is that correct?
That is correct.
No further questions, Your Honor.
Anything on redirect?
No, Your Honor.
All right, the witness is excused. Defense may call its next witness.
Thank you, Your Honor. I would like to call Dr. Dana McGuire to the stand. Could you state your name and age for the record?
I'm Anna McGuire, and I'm 42 years old.
Please tell us about your educational background.
I received my Bachelor of Arts from Campbell State University, where I graduated with the highest honors. I also received my master's degree in psychology.
Did you have an area of focus?
My emphasis was on the sociological and psychological dysfunctions of the family structure. I was also instrumental in developing a family crisis intervention program that is being used by police departments nationwide.
What is your area of expertise?
I am a practicing psychologist. I specialize in dealing with abused and battered women. I also offer private counseling for abused and battered women.
How long have you been a practicing psychologist?
I've been practicing for 17 years.
How many women have you interviewed or collected data from?
I've collected data from over 300 battered and abused women. I've also heard fragments of over 500 stories from battered and abused women.
How many books or articles have you published?
I have written numerous articles in magazines and periodicals highlighting the plight of battered women. I've also written one book on the same topic.
Have you testified in court before?
Yes, I've appeared as both a witness and an expert witness and have been involved in both criminal and civil trials.
Your Honor, I would like to make Dana McGuire an expert witness.
All right, any objection from the state?
No, Your Honor.
All right.
Dr. McGuire, could you please describe for the court what is a battered woman?
I define a battered woman as one who is subject to any forceful physical or psychological behavior by a man against her will.
How do you define a battering couple?
To be a battering couple, they must go through at least 2 battering cycles.
Please describe a battering cycle.
The battering cycle is broken up into 3 phases, the first being the initial, the second being the acute battering phase, and the third being the loving phase.
Please describe the first phase.
During the first phase, tension builds and there are minor battering incidents.
What is the difference between the second and the first phase?
The second phase, also known as the acute battering phase, can last anywhere from a few hours to several days. During this time, the battering man unleashes an uncontrollable amount of tension.
What is the result?
The result is physical and psychological destruction.
What is the relationship between the third and the second battering phase?
The third phase is one of extreme kindness and contriteness.
How is the couple's relationship at this time?
Inside, the battering man secretly believes he has taught the battered woman a lesson, while she believes that the battering man is a little boy desperately sorry for his actions.
Why would a woman stay in such a relationship?
Their psychological dependency on the man is enormous. Some stay because they have no other legal or economical choice. All battered women stay because they have internalized what I call learned helplessness.
How do you describe learned helplessness?
Learned helplessness is the theory when a person believes he or she cannot control what occurs.
How does this relate back to a battered woman? Your Honor, may the witness see her statement?
Right. You may refresh the witness's recollection.
Administrator, can you please pull up the Dana McGuire's witness statement?
My mom's computer got disconnected, so she's trying to reconnect.
In the alternative, counsel may lead the question rather than refer to the document.
Okay. Battered women's, their every effort.
Battered women's every effort to avoid violence ends with violence, and so they then take refuge in extreme passivity.
Do you have an example of their passivity?
One woman I interviewed after she shot and killed her husband believed that he would fully recover from his injuries because the 4 bullet wounds to his head were not that severe.
Is this a tested theory?
Dr. Samuel Michaels has tested this theory on dogs.
How does Dr. Michaels test his theory?
Dr. Michaels placed dogs in cages and administered electric shocks at random intervals.
What was the outcome of the experiment?
At first, the dogs tried to avoid the shocks, but when that failed, they became passive and ceased any voluntary movement. Even when the cages were left open, the dogs did not try to escape.
Did the dogs ever avoid the abuse?
No, it took repeated dragging for the dogs to ever try to voluntarily avoid the abuse.
Has this theory only been tested on dogs?
No, it has been tested on basically every kind of animal with the same result.
How do your studies prove that battered women are different from non-battered women? Your Honor, may the witness see her statement, or may I prompt the witness?
You may refresh recollection.
Thank you, Your Honor. Battered women have low self-esteem.
Battered women have very low self-esteem and value highly traditional notions about loving relationships, and so believe that if they fail at marriage, they fail at life.
How do the women react to the man's violence?
The women believe they are the cause of the man's violence and will go to any means to manipulate their environment so that he will not be displeased.
How do these women respond to stress?
Battered women have severe stress reactions, including physical and mental breakdowns. Battered women are also very depressed.
What are battered women's emotions?
These women live in constant fear. Battered They're increasing. They're increasingly angry that they cannot better control their lives and their mates, and that they are so dependent.
What causes a battered woman to get angry? Your Honor, may I refresh the witness's memory?
Yes, you can have the document placed on the screen.
Can you please, Administrator, can you please move to the second page?
Could you repeat the question, please?
Yes. What causes a battered woman to get angry?
I'm sorry, I can't remember.
Your Honor, may I move on to the next question?
It's your examination.
Administrator, can you please remove the exhibit? Thank you. What do the battering couples believe about the violence?
The battering couple denies reality and reassures themselves that no one will ever get hurt despite overwhelming evidence to the contrary.
Dr. McGuire, let's talk about your interviews with Mrs. Barrett now. In your expert opinion, would you consider Mrs. Barrett to be a battered and abused woman?
Yes. At the time of the incident, I had 3 opportunities to interview Mrs. Barrett, and I found that she was a classic case of a battered woman.
Would you please show how Mrs. Barrett fits your description of a battered woman?
Like all battered women, Mrs. Barrett suffered violence at the hands of her husband for years. The violence committed against her was extreme, and her stress was tremendous.
Could she have ever left her husband?
No, she could not break free from her one passivity and dependency. She could no more have broken free from her husband than sever her right arm.
How does Mrs. Barrett relate back to the cycles that you talked about earlier?
Like all battering couples, the Barretts went through the cycles of initial, acute, and loving phases. Mrs. Barrett basically lived from one loving phase to another, denying the reality of her husband's cruelty and her own passivity.
Could she have controlled her actions that night?
No, she could no more have controlled her actions than the rising of the sun.
How did she view the situation?
She saw it as a betrayal of her every effort to pacify her husband into staying with her in the marriage.
How did she see her husband?
She saw him as what he was, a man capable of causing her serious injury or death. From a psychological viewpoint, it was at this time that her circumstances were made clear to her. It was simply a tragic end to a tragic marriage.
Thank you, Your Honor. No further questions.
Cross-examination.
Is it true that you collected over 500 fragments of stories from battered women?
Yes.
Was this research done in a controlled database?
I believe so.
Have you interviewed Mrs. Barrett before?
Yes.
Did these interviews happen after the death of her husband?
Yes, they did.
Did you have multiple meetings with her?
Yes, I had 3 meetings with Mrs. Barrett.
Is it true that your theory of passivity and learned helplessness means a woman loses sight of being an independent person?
That is true.
The word passivity means not in action. Do you agree?
Yes.
The theory of learned helplessness goes hand in hand with passivity, correct?
It does.
Do you believe that Mrs. Barrett was being passive when, if at all, she shot her husband?
No.
No further questions, Your Honor.
All right, any redirect?
No, Your Honor.
All right, any further witnesses for the defense?
The defense rests, Your Honor.
Any rebuttal from the city?
No, Your Honor.
The parties have rested. The state may commence with its closing argument.
Thank you, Your Honor. May it please the court. Today we are here to determine that Mrs. Barrett did not kill her husband as defined by South Carolina State Statute 16310, which states, murder is the killing of another person.
I'm sorry, is this the defense argument or the prosecution argument?
This is defense.
Prosecution goes first.
I'm sorry, our thing says defense is first.
Go ahead and continue then.
Thank you, Your Honor. May it please the court. Today we are here to determine that Mrs. Barrett did not murder her husband as stated by state statute of South Carolina 16310, which states, murder is the killing of another person with malice aforethought, either express or implies. Today, the prosecution accused my helpless, abused client of murdering her husband, when in reality, she was defending herself from her vicious husband, who she so dearly loved, and feared being ruthlessly killed and strangled by a belt by her own husband. In the case of State versus Johnson, malice is defined as the wrongful intent to injure another and indicates a wicked or depraved spirit, intent on doing wrong. Even up to the night of Mr. Barrett's death, my client, Barbara Barrett, was trying to protect their marriage. Does this sound like a person who would want to murder her husband? Today, the prosecution's faulty case fails to prove without a doubt a forethought or malice. Today, our expert witness, Dr. McGuire, defined for us a battered woman as a woman who experiences any forceful, psychological, or physical behavior against her will. Mrs. Barrett is a clear example of this, as she has been harassed ever since even her first encounter with Mr. Barrett and beaten all the way up to the incident. Dr. McGuire also identifies for us a battering couple as a couple who goes through at least 2 battering cycles made up of 3 phases. These phases are the tension building phase, the acute battering phase, and the loving phase. Mrs. Barrett endured at least 30 of these brutal cycles throughout the 10 years of their marriage, never lashing out, but always trying to protect and restore their marriage, even to the day her husband died. Today, the prosecution's witness, Ms. Porter, was shown to be an untrustworthy witness. She is the only witness of the incident, and she is a thief, a liar, and she is uncertain of pertinent information that is strictly required for accusing my client of being guilty of murder. Also, their officer, Cheney, his negligence and failing to follow protocol over and over again cast doubt on the validity of the scene, the report, and his treatment of my client. This officer led a hysterical, woman who required medical assistance past the deceased, the belt that her husband had come at her with, and the gun. What kind of an officer would do something like this? Then he proceeded to take a confession from her without reading the Miranda warnings to her. And he called it a statement. My battered client, Mrs. Barrett, is not guilty of murder, for there was no malice of forethought shown today without doubt, simply a tragic case of self-defense against the man she adored and needed. And we ask for a verdict of not guilty. Thank you.
All right, thank you, counsel. Counsel for the city, closing argument.
Ladies and gentlemen of the jury, John Walker Barrett has died because of the defendant. He was killed in a fit of anger on the part of Barbara Barrett. While he may have been a detestable husband, he was still a living being, and she had decided to take his life that day. The defendant purposefully killed him in an act of anger after tensions had grown between the two for the span of their marriage. Past abuses held built up within the defendant, and she released them on him when he chose to announce a divorce that evening. The victim had returned home on the day of the murder, calm and willing to take things rationally, but the defendant struck out violently after he announced she wished to separate from her. She had started an argument between the two during dinner, and instead of accepting the divorce and moving on, she killed him in anger afterwards. Barbara Allen Barrett had been seen with a gun earlier that day. That gun would go on to be used to kill John Walker Barrett. The housekeeper had identified 3 gunshot noises coming from the backyard on the morning of the day of the murder. Lee Porter then saw the defendant enter the house through the secret passageway holding a gun. The same gun would be later used to kill her husband. She had first crippled him with a shot to the leg before shooting him 3 times in the back as he attempted to flee. While the victim cannot be returned again, convicting the defendant will at least prevent the death of another at the hands of Barbara Barrett. The court must demand that Barbara Allen Barrett be sentenced with first-degree murder. Thank you, Your Honor.
Thank you all. Anything else before we take a brief recess? All right. I believe, Madam Administrator, how much time do we have for a recess before we come back for comments?
So it's currently 2:43. Let's say that we'll be back here at 3:05, 3:10, somewhere in there. What do you think, Judge?
I'm fine with that. And then I will finish my comments and email them off
Okay.
before providing verbal comments.
Yeah, that sounds fantastic. So jurors, you have your ballots that you can at this time begin to work on and process as Judge Geith will do, and you can email to me. Participants, please make sure that you change your names back to your real names so that Mrs. Devaney can set you out to your correct break room. And then, yeah, we'll go ahead and break right now. For those of you that have been watching the live streaming, thank you for joining us. Parents alongside proctoring, thank you for holding steadfast to integrity and encouraging your students to be above reproach. We'll join back here at 3:10 for closing remarks from the judge, some Q&A, and then I will be working on the ballots so that I can give a tally on today's trial. So we'll see you guys back here at 3:10. Thank you so much.
Yes.
Hey, you're still here. What did you
Yeah.
think about doing Zoom for DUI court on Wednesday?
Just a second. I'm on a
everybody. Welcome back. I think everybody's attempting to come back from their breakout rooms. I have received scores from Judge Skype, and I'm just waiting for the jurors' scores so I can their ballots. Jurors, if you are online and you can hear me, I see a few of you. Jessica, you're there. You're more than welcome once you email me your ballots. If you want to hang out and listen to comments and continue to participate in that way. But if you need to leave because of time constraints, that's fine. We totally understand. Just as long as I can receive the ballots via email. I'd like to congratulate both teams. You guys worked really hard this past 15 weeks. And I know how the process works because I've seen it unfold many times. And at the beginning, it's always kind of crazy. Again, that grammar stage, learning things and kind of like, why are we learning this? And digging into it. And maybe you watch movies like, what was it? Inherit the Wind, right? In the trial scene in Inherit the Wind. That's a way older movie, but talked about that, right? In Defeating Darwinism, or maybe you watch 12 Angry Men to see what a jury looks like. And so yeah, there's lots of things I'm sure that you did and had fun processing, but it's been really neat for me to see just over the past couple weeks, roles really being absorbed, and that time when you guys are talking and having conversations, and we're of course not coaching, but listening in, and you guys coming up with strategies and developing your questions. It's been a lot of fun. So I appreciate all of you sticking in it, especially with all of the quarantine measures that are in place, the social distancing and protecting us. That it's another level of learning for you guys, learning etiquette protocol, when to pop in on and speak, when to have a meeting, right? You guys are teams, you're working in teams, not just as yourself. So you rely on one another. And what do you do if someone's not showing up? And all those things that go along. I just commend you because I know it's not easy. And you weren't necessarily prepared to kind of go that route. So thank you for working hard, diligently unto the Lord and for what you needed to do. I'm gonna give it over now to Judge Skype so he can share with you some comments and do some question and answering while I wait for the ballots. And as soon as I receive those, Judge Skype, I'll let you know in the chat box that I'm ready to share, but I'll leave it up to you. Thank you.
Well, I've got plenty of time, so we can take all the time you all want for questions as well as some feedback from me. But thank you all for letting me participate with you. It's a pleasure to meet you all. Can I ask really quickly, what's your age ranges?
About 13 to 15.
Okay.
Yeah, about that.
Okay. All right. Well, I want to say I'm always impressed when I do mock trials as a judge for high school students and others. And maybe it's me in my late 50s being somewhat forgetting what it was like at that age, but I don't think I was as well put together as you all at that age. I wouldn't have been able to pull this off as well as you did. I'm going to also say that I've been a trial attorney. I'd been a trial attorney for a long time. I teach trial advocacy skills to other attorneys in continuing classes. I read a lot about it. In my first profession as an intelligence analyst, I was primarily a linguist and a cultural expert. So I'm really into language. I'm into how you present. I'm into the art and craft of trial. Though the technical aspects are important, my comments to you aren't about technical aspects. I'll make a couple of comments about them, but I'm mostly staying away from it because it's all legal concepts and concepts about rules that I don't expect you to know. Or have to deal with. So how many of you have, one of the organizers had mentioned To Kill a Mockingbird? Just raise your hand so I can see it on the camera. How many of you have read or seen the movie To Kill a Mockingbird? Okay. How many of you have seen 12 Angry Men? Inherit the Wind? Okay, it's always a good one. I expected to get a few there. How about A Few Good Men? The Tom Cruise movie about the military court? No? Okay. Trial, I like people to have read those from a literary perspective. There's one important thing to remember that's a similarity and one that's not. All trials are the art of performance. That's the thing that's similar with movies and books. Every trial is a performance. And what's the purpose of the performance? The purpose is to get people to emotionally bond with your side of the case so they'll decide it or have a better chance of deciding it the way you want them to. That's the true thing that real trials share with the trials in real life, in movies and books. Real life trials in movies and books share that aspect. It's a storytelling exercise. It is a narrative exercise. The one thing where fiction, movies, literature rarely meet the real world when it comes to trials, it's never as easy as it looks. It takes 10 times longer, and you have to be far more prepared. And frankly, the cases you see in the real life, you sometimes go, nobody could have written this. That's exactly what been my experience there. I always run into something that's like, you're kidding me. That's the part that doesn't quite match up, and it takes a lot longer and it takes a lot of discipline. So, how many of you are actually thinking that law might be a pursuit for you as a profession? One? Okay. All right. Preparation was what the team that was prepared the most. When you see the scores, they got the better score from me. All right. The preparation and the style of presentation. I'm going to just go on. I'm not going to call out people or what it was. I'm going to do some general comments to tell you what I liked and didn't like in various presentations without calling out individuals particularly. So this will be done in a general way. When I talked about technical aspects, there were things that were clearly missed. Foundation is a word you hear sometimes. Laying a foundation is setting out the proper facts in order for you to make an opinion or to come to a conclusion. When you deal with experts, it never goes the way you all presented it in real life. I thought the second round, the introduction of defense expert, and in the first round, the introduction of the prosecution expert were closer to the mark, though I think round two, the defense expert was close to the ideal. You laid good foundation, you put out all the qualifications, you then had the person qualified. The prosecution in round two completely failed to ask for qualification of their expert. That should have been grounds for the defense to come in and say, hey, move to exclude all the opinion provided by the officer as to those issues, or the forensic pathologist as to those issues, failed to lay qualification. It would have been granted in a real court, right? That's an issue. But when you talk about foundation, it also applies to lay witnesses as well. If you rush in and just start asking conclusory, you miss the point. The one person in the room, the one group of people in the room who have never heard the facts are the jury. The attorneys for both sides have been through the facts for months, sometimes up to a year or more. You all know the facts so well, you sometimes forget all the little foundational facts that make you get to your argument. The things you've considered and discarded is unimportant to get to your point. but the jury never sees it. The judge is better at it, even though they haven't seen the case except for maybe preliminary motions. But the judge has got decades of experience and knows a fact pattern when he or she sees it. The jury doesn't. They're all lay people. And if you rush laying out your foundation if you rush laying your foundation and go right to some juicy fact, you miss it. The jury misses it. They get no chance to anticipate where's this going. The anticipation of where your argument's going is part of the process the jury uses in being able to identify with it, to be able to accept your conclusion. If you just lay a conclusory fact out there without the prep, they may not be ready to accept it. And you lose your point with them. All right. So that's part of foundation. Take the time to feed it into small bits so that they understand and can agree. They can come to the conclusion at the end, yeah, you thought about that, and that's the right conclusion. The other thing I want to caution people about, opening argument, or we call it opening statement. You have an opening statement, but you have a closing argument. The opening statement should not have anything in it that's controversial and should stay away from things. I made a particular note. The prosecution in round one called it a violent and brutal, or maybe it was the defense. Yeah, no, it wasn't in opening, it was a little later, but made a statement in opening to the effect of calling it a violent and brutal crime. You can do that to a degree in opening statement, but the less that is proven true by the facts, even if it's argument about how you interpret facts, the more you lose your credibility. At the end of the day, in an argument of this kind, your most important asset isn't the facts, because the facts are the facts. You can spin them, you can emphasize them, you can de-emphasize them, but at the end of the day, a jury is going to believe you based on your personal credibility. So if you oversell in the opening, and then the facts are arguably, even if you believe they're right, your facts are right, maybe your interpretation you believe is right, but the facts may be argued a different way, you lose credibility. That could have the jury not necessarily accepting it, especially if you want them to make a leap on a set of facts to a conclusion. You want to build credibility. So you want to avoid inflammatory rhetoric or overselling in the opening and just lay out bare bones. The other thing is procedurally, this doesn't work like a real trial. The whole issue of whether the defendant was properly Mirandized and gave an opening statement would have been resolved in pretrial motion. It's what's called a 3.5 hearing, a criminal rule 3.5 in our state. And it says that if there's a statement by defendant that's being offered, a confession or something else, and there's some question as to whether it was admissible at all, it would be dealt out of the presence of the jury, because even to suggest there was a confession when it's not ultimately admissible is prejudicial to the defense. So that would have been dealt with ahead of time. In the first round, I would have probably admitted the confession because of the way it played out. In the second round, defense counsel did a great job in pointing out in an uncontradicted way that there was no Miranda, and I would have suppressed it in the second round. So there's that can have huge significance, because part of the credibility that the jury, that the parties have to sell is the credibility of their party, right? And that was the biggest stain on the credibility of the defendant in the case, is a confession and a statement. Because how do you believe her about her state of mind if she confessed, right? And the confession's valid and admitted. Another thing that doesn't matter to you guys, I didn't grade you on it, but I wanted to let you know, is The statements of witnesses are not used or admitted at trial in most cases. They'll be marked as an exhibit, like the statement, the written statement of the officer is almost never used if the officer testifies live. Same as with the expert therapist and the forensic pathologist. The pathologist's report will come in, but not a personal statement. If a person testifies live, their written statement is what's called hearsay. It's something that was written outside the presence of the jury and is not admissible unless there's a reason the person can't testify live and it's otherwise reliable. But you can still have it marked as an exhibit, use it to impeach them, like point out a contradiction. It doesn't need to be admitted to be used to impeach. It doesn't need to be admitted to use it to refresh their recall. You can just say, hey, there's exhibit 1. Does this help you refresh your recollection about what your testimony is? Yes. Or hey, here's exhibit 2. Isn't it true that when you wrote this exhibit on this and such day, you said something different than you just told us? That's refreshing, that's impeachment, but the document never comes in for the jury to see physically as an admitted exhibit. It's a technical issue, but it makes more sense when you realize the whole process of the trial is so that the judge can determine through the course of people's presentations what is sufficiently reliable evidence for the jury to look at it. And so it's all about preserving and preventing the jury from being unduly biased by evidence that may not be perfect for a particular use. So that's a technical aspect. I didn't grade you on it. I just wanted to let you know about it. A few things on individual presentations. In the first round, good cross-examination of the officer on the first round, but a better cross-examination in the second round of the officer. That was a grueling cross-examination. I can't remember who did the cross-examination in round 2 of the officer, but the fact that he had another job, the fact that you pointed him right to his report where he says, I don't recall Mirandizing her, you made him look like a schlub. That's perfect. If you're going to go after somebody, have that kind of evidence, because that's really what's important. So they were both good cross-examinations on both rounds. I think second round is better. Dr. May in the first round, and the defense in the first round, let him get away with it. He said, a violent and brutal, his exact quote, that should have been objected to, it would have been sustained. An expert is not supposed to provide opinion testimony that characterizes the evidence. Absolutely off limits. He can give opinion about scientific conclusions because that's what he's there to do. Leave the whole idea of calling it violent and brutal is for the prosecutor's argument at the end of the day after the evidence comes in. Dr. May describes it as being, well, it was based on my opinion, 1 bullet wound to the arm, front to back, 3 bullet wounds in the back, 2 in the chest, 1 in the leg, and then he's flat on the ground, helpless from the bullet wounds, gets a coup de grace in the head. That's the doctor's testimony about the order and sequence. The prosecutor then gets to come in and argue, it was brutal. Shot him once, he's in fear. He moves to run away, shoots him 3 more times. He's flat on the ground, shoots him in the head. That's brutal and violent. That's the prosecutor's thing to do, not the experts. And if the expert had done it in the trial, it would have been suppressed and eroded the credibility of the expert. You would normally take more time to develop the expert witnesses than you had allowed for. That's an artificial thing having to do with the format, not with any skills of yours. This isn't for you either. You guys have the mock trial problem that's been presented to you. I'm familiar with this particular mock trial case, and it's been around for a while. It's probably a good idea to move away from it because the battered woman syndrome has actually been disfavored in the courts as an acceptable defense at all, and it won't even get to a trial anymore. So it's not a very realistic one to use. If you have another one and you want to use the abuse, the history of abuse and PTSD and its effects on diminished capacity, which is how it is validly used these days, I would move to a more recent case that doesn't use that coded language. In closing arguments, in both cases, both rounds, conclusions were made about facts. It's as if your arguments, and this is probably the biggest criticism I have, is that some of the presentations, especially closing arguments, look like they were written in advance and just recited for the closing. Because in both closings, there were facts asserted in closing by the attorneys that were never actually brought out during that round. All right, and it's most startling in round number 2. Where was that? Yeah, in round number 2, the city's closing argument referenced expert testimony from Dr. May that was never provided or requested from Dr. May in that round. It was in the first round. They actually got it in about the angle of fire, the sequence of fire. None of that actually came in during the second Dr. May, and it's the same one where they had failed to qualify him. And so that one was the most egregious. There were some others on both sides in both closings that said, you got to be careful of that. And that's one of my last comments. And then I'm going to open it up to questions if you've got them, because I prefer to spend most of our time answering whatever questions you have. But that's the last point I want to make. You've done the job of putting on a trial, preparing for it, putting on the witnesses, getting there. Closing argument is the dessert at the end of all the work. It always has been. The subject I love to teach the most is closing argument. And it literally is the dessert. If you've already planned what your dessert was 5 months ago and it's sitting back there in a fridge and you pull it out for your closing, it's not going to look very appetizing. You shouldn't do your closing argument until you've seen all the evidence that's admitted at trial, and you have to make sure that everything that you want to put into your closing argument was admitted at trial. So you want all your facts that you need to present that dessert, because you have no greater liberty in a trial than your closing argument. It is the wildest, most open-ended thing you can do. One of my best arguments and closing of all time that I personally delivered was about 6-7 years before I became a judge. And I had a whole written argument ready with all the points I wanted to make based on what came in at trial. I was on the defense in that case, so I went second. I heard the opposing party's closing and tore up my closing argument and threw it away. My opposing counsel went through and called, in his closing argument, called my legal argument ridiculous, called my client's story ludicrous, and said it doesn't make sense. And he used each of those 3 words, ridiculous, ludicrous, doesn't make sense, 5, 6, 7, 8 times during the course of his closing. it got so repetitive. And so it was like he had no argument. All he could do is throw names at it. Ridiculous, ludicrous, doesn't make sense. So I wadded it up because it hit me. I've got the perfect way to make my argument and serve up an ace on him. I went and I recounted it with the jury. I said, ladies and gentlemen, how many times did he say ridiculous? How many times did he say ludicrous? And I was mocking his voice. How many times did he say it doesn't make sense? And I said, I looked at the jury and I said, I've heard it so many times that all I could think of was Vicini and the Princess Bride going, inconceivable. And the jury laughed. This was after about 2.5 weeks in trial, where the parties, almost all of the witnesses, were speaking in Chinese Mandarin with a jury of complete English speakers, no Mandarin speakers. So through translators for 2 weeks. So they needed to laugh. So they laughed. I let them pause. And then I let them finish. Even the judge went like this because she didn't want to be seen to be laughing. And then I looked and I said, you've all seen the movie. So you know what Inigo Montoya says next. I don't think that word means what you think it means. And it sells. They were all over it. It was a beautiful moment. And then I look over at the counsel and his client and I say, that's the problem with their case. They don't know what it means. And then I take 10 minutes to make my argument about why I should win, presented them with the evidence of why I should win, and I sat down. Total time up and down, 10, 12 minutes. Jury's out for 2 hours, gives me everything I want. That's why you have to be ready to abandon your closing argument. Because if it looks like it's written and you're reciting it, you're not going to catch their attention. You're not going to get them to think about what you're doing. You're going to actually put them to sleep. If you are reactive and ready to take advantage of what's in front of you, you're going to have a much more enjoyable closing and much more successful. So remember, the art of presentation is about rhetoric. It's about your language, your tone, your preparedness of the facts, and at the end of the day, making a connection with the people who are deciding it for you. And you cannot undervalue that. You don't have to connect with everybody on a jury. Or if you're in a boardroom, you don't have to connect with everyone in a boardroom or in a meeting of peers. This goes to all things in life. When other people or a group of people are making a decision and you are trying to influence them, you don't have to influence and convince all of them. You only have to convince a few of them and give them the tools to make the argument for you when they're back discussing what they're going to do. All right. So that's what I wanted to tell you. I think you all did really well for being high schoolers. Like I said, I wasn't that put together when I was your age, so I don't think I could have pulled it off. But with that being said, I'm done with the lecture-y bit. I want to field any questions you have.
So you said the battered woman argument isn't very good. Why is that?
It has to do with the science. And it's funny, this particular case lesson comes from the late 80s. And the science around the battered women, when it became the sort of go-to, was in the mid to late 80s. And there was some scientific research to support it. But it's been through both federal and all sorts of state courts. And they allow it to be presented because it's scientifically valid, but with the exception of a couple of cases, it's almost never been successful. And the reason that it shifted is because it's not very successful, except for in rare cases. It's because it almost never completely negates culpability. You might get them to agree, and this comes into a concept that you're not expected to know about. It's about what the person's charged with and lesser included offenses. This is a case that you're presenting is a case of murder in the first degree, premeditated, malice aforethought. By the way, good closing argument from defense counsel in round 2. You actually put the legal standard in there. That's exactly what you should do. If you think you can beat the legal standard with a good argument, put it in there so your authority goes way up. But malice aforethought requires premeditated intent to commit the crime. Sometimes, though, prosecution will include lesser offenses that are included in the same fact pattern, like manslaughter, murder to manslaughter, reckless homicide. Those are all less than, and the standard of proof is less. Like manslaughter, just it's considered the passion of the moment killing, right? Where someone is overborne by something and they commit the murder. They're not relieved of it. It's just not first degree murder. Negligent homicide is reckless. In other words, gross recklessness and disregard for someone's safety causing a death. Those are all forms of homicide. And they are all criminally culpable. If a criminal prosecutor pleads a lesser included offense, it puts the defense in a bind about it. Because yeah, maybe you can prove with a case of battered wife syndrome, as it was called at that time. Now it's called, what's that word? It gets used all the time. It's battering and its effects. So it takes out the gender connotations of battered woman syndrome, which is not very good. It also takes out the fact that it's a syndrome, because it's not. It's actually violence causing a recognizable PTSD response in people. So it's a type of post-traumatic stress that results in certain types of behavior characteristics. Now, you can eliminate intent with that, but you don't eliminate liability for a lesser form of murder. So it's very rarely effective. And it has a lot of politically incorrect connotations to continue using battered woman syndrome.
Thank you so much for that feedback.
Yeah.
Oh, Trin, can you turn?
Next question.
Apologies.
What's the weirdest case you've ever been a judge for?
The weirdest case I've been a judge for.
Your volume's down. Hello, can you hear me now?
Weirdest case.
Judge Geip, I just wanted to say.
Oh, sorry, go ahead.
Something regarding that trial. This is the last year Classical Conversations is using that trial. It's being officially laid to rest. So thank you for the confirmation that that is a good choice. And we're actually piloted a brand new trial this year, some of the communities. So we hope you come back next year to participate in our brand new version.
Glad to help. I always like to get something fresher than that. And we should all be more conscious about the language that gets used in some of these older models. But I'm going to turn it around, a good lawyer response. Define what you mean by most unusual case. What's... Because I have some things that fit that model, but you may not think of them that way.
I suppose something for over some reason that you would think doesn't require going to court for.
Oh.
So outlandish you wouldn't think it would actually happen.
In my current role as a judge, Before last year, I was a part-time judge in a number of locations for about 6 years. I became a permanent full-time last fall. The court I'm in currently is 95% criminal work. All right. I have been a judge on some civil cases that I thought should never have come before me because I'm like, really, this is where it's at? But in the criminal context over the last 9 months, yeah, I had one case where I thought it was legitimate. It was brought by the city, but I questioned why they would do it. And it was an obstruction charge against a homeowner for not letting the police into his home when they were there to investigate alleged domestic violence, not by the homeowner, but alleged domestic violence by the homeowner's son against the son's girlfriend. And the son and the girlfriend weren't even present when the police showed up. And technically, the officers had a good reason to ask to enter, and he refused. That's technical obstruction. And so it had to go to a jury, and I thought that could have been handled differently. But that's the sort of thing, and the jury made its decision. It's the sort of thing where you go, yes, that's the law, and this is why I find it odd. Not that it was a right or wrong decision to bring the case, but yes, that's the law, and there's a right to bring it, but it misses some of the decisions. It showed a lack of empathy in making that charging decision. And I thought if the prosecution had been more empathetic about the bind the man was in because of his son, that it may have had an alternate way to handle it. So based on that, I'd just say this. Prosecutors, defense counsel, judges, jurors are all human beings. They all bring with them the positive and negative qualities of humans. All right. And they err sometimes. And I think that the biggest thing everyone can bring to the court when they're participating in court is a sense of empathy and compassion for what everyone's got to do there. It doesn't mean you excuse them and don't require them to do what they're supposed to do, but you should have some empathy that sometimes they're doing a hard job. One of my last cases as a criminal defender was defending a person accused of the rape of a child. And it was not something that I enjoyed doing, but it was my job. And having compassion that people are there to do a job, even when it's hard. Having compassion for the defendant who's going through a hard time, even when it's their own fault, or it's yet to be proven if it's their fault. But if you bring compassion and empathy to the work, you'll find that it's easier to get along with people and easier to go through that exercise. It looks like our tallies are almost ready. Is that correct? Okay. All right, almost there. One more question before they're ready to give you the results. Yes.
Just kind of more a simple question, but how long has what's the longest case that you've participated in? Like, how long has it taken?
The longest case I've been involved in was as when I left being a criminal defender, I became a civil rights attorney, and I had a 1.5 month trial in federal court, and longest trial of my career. And it was very involved, and it had to do with, I represented 2 plaintiffs, one of whom was the estate of a person who was killed by the police, and the other was the person who was with them who was severely beaten, almost died but survived. And so it was that was a long case. All right, it looks like is the tally ready? Oh, one more. All right, one more question, and then we'll get the tally, and then we'll be free to answer any other questions. Anyone else? Yes, Genevieve.
Did you have a preference between judge and juror, judge and attorney, or were there parts of both that you enjoyed?
Oh, when I became an attorney to be a trial attorney, because of some things that had happened in my first career. I made the decision. I hadn't thought about law until I became a lawyer. I was 35 when I became a lawyer. And because of some things in my first career, I experienced some discrimination, and it made me want to change things. And so I became a lawyer, and I loved trial work. And it took me a long time. When I finally came around to the decision to try to become a judge, it was because I was done with being an advocate, but I still love trials. I actually love watching trials as a judge. So for me, becoming a judge didn't change anything about the love of the trial process. It just relieved me of the burden of having to spend months and months and months preparing to do the show. Now I get to watch and manage the show, and it's almost as good. I never get to make those beautiful little arguments like the Princess Bride reference. I don't get to do that as a judge. And so I miss that. But I still get to see great argument by attorneys. I also get to see some really bad argument. But, I get to see trials run, and that's what I like about it. I love serving the public. I've always served individuals or the public. I never got into the law to make money. I got into it to be of service to others. So being a judge is the dream job for me. I get to watch trials, serve the public, and yeah. So, Shelley, are we ready with the results? Two minutes away. Okay, one more question.
Help to be good at improvising when you're in court?
What's that?
Does it help to be good at improvising when you're in court?
Yes and no. The actual number one skill to be a good trial attorney is preparation. All right. But like I said earlier, if you're over-prepared and you're unable to improvise, it can make it difficult. I would say the number one skill, rather than calling it improvisation, I would call it resilience or flexibility. You have to be able to, and you have to have good judgment, because you have to know when it's appropriate to suspend your plan and implement something else. I've seen some people take that risk and fall on their face because it wasn't the right move, or they didn't implement their sudden inspiration in the way that was useful. I've done it myself. I departed once. It's the contra story to the Princess Bride reference. I tried that in another case with something else, and actually it happened before that, and it didn't go over half as well. And I always wondered, I got a split decision on that case, and I always wondered if perhaps my taking the route and rolling the dice with that change was something that influenced it. I didn't get a chance to talk to the jury in that case, so I was never able to answer whether that affected the outcome. Yeah, so How many of you had done anything as far as a presentation like this before? Is this the first time? All right, so 2 of you have done something like this before? Okay, all right, all right. Let me ask you, what's the most challenging part of this for you?
Writing my opening statement, I came through a lot of writer's blocks of sorts.
Mhm.
I couldn't figure out how to word it, and then I got confused with our defense theme and our prosecution theme and wrote multiple statements on the wrong theme.
Yes, it can happen sometimes. Anyone else have a particularly issue that was challenging in this? Let's see, who's Trinity or Genevieve? You have your hands up.
Okay, I'll go first. I think I think the performance is actually, for me, significantly easier than the preparation. You see, since our CC community didn't have enough teachers to do the next grade, the next level for me, I am repeating mock trial again. That's why I'm here this year. So last year, actually, I did this, but I only played as witnesses. So this year it was difficult because I was an attorney and I have to get the questions that I want out of the witnesses instead of being the witness like last year.
Mm-hmm. Yeah. How about you, Genevieve?
I was just gonna say it's kind of hard for me to get into the character of the witness I'm playing, mostly because I can't relate to her in any way. And so, I don't know, that was difficult for me.
Which witness were you playing again?
I was Dana McGuire,
Okay.
psychologist.
Yeah.
I feel the opposite about playing Dana McGuire. I have considered psychology, and I like to listen to podcasts and read books about psychology. When I found out that this case had a psychologist in it, I begged my tutor to let me be the psychologist, and I got my way.
Yeah. You know, there's an interesting thing. So I have an identical twin brother who's a psychologist. And when I was dealing with a case a long time ago, I said, what do you, had a psychologist doing testimony that had to do with psychological impact on victims and certain types of things relating to a very similar topic to this, actually. It had to do with PTSD responses in certain types of violence victims. And I just couldn't quite understand how to approach this particular interrogation of this witness, this psychologist witness. And so I went and talked to a psychologist. It happened to be my twin brother. He was happy to give me the time, and he walked me through it. When you prepare, it's a little artificial for you to play someone you're not. But let me challenge you with that. Every exercise of persuasive presentation requires you to emphasize an aspect of character that may be not your own. It requires you to play some aspect that isn't you. You can handle that in a couple of ways, all right? You can do what I do frequently. I'll educate myself and then put myself into that role to help me figure out how I'm going to tear that role down, if I'm attacking it, or shore it up if I'm supporting it, like I did talking to my brother. Another way is to say, and be very open and say, look, this isn't my area. That's why honestly, you're playing the psychologist, you just open up and say, I don't know much about this, but this is what I'm told. Can you guys identify for me what the two differences in those two approaches are? There's two things that are different in how you approach it. One is a positive thing for each of them, and the other is a negative thing about those approaches. Can you guys identify what those are? Yes, Trinity.
I think for playing the role of maybe a characteristic or knowledge that you're not, actually very experienced on. I think the positive thing about that one is that if you can work your way through it, then you'll be much more convincing and have more authority. But if you don't have the sufficient knowledge and evidence for it, then it's going to backfire on you because you acted confident when you really didn't know.
Correct. And what about the other model? Who's got an idea of what the positive and negative of the other model is? Where you admit to lack of knowledge in front of a jury or in front of the opposing party. Where you acknowledge this isn't what I know. Yeah, Genevieve.
Well, the negative side is now they won't trust you as much because you've admitted you don't exactly know what you're doing.
Ah, two-edged sword. They won't trust you if you then assert authority about it. They'll trust you to know that you're telling the truth. So that's a two-edged sword, but it's partially correct. You gain credibility at the sacrifice of authority. So that's the point. That's actually very close to the point. The other thing that it does for you, Genevieve, is that it's not a liability as long as you can provide them someone else who can fill the gap. All right? That's why you have experts. All right, it looks like, am I correct? Are you ready? All right, I get a thumbs up. So let's see what the results are, and then we'll do the other questions afterwards.
Hi, guys. Oh, my goodness. Thank you so much for being so patient. Thank you, Judge Geit, for sharing insight about why you love what you do and encouraging our students and covering for me as I added furiously. Got to remember, I have 3 jurors, and each juror has like 4 pages, and plus Judge Geit, and I wanted to make sure I did it twice because I'm the only one counting to make sure I got it right. Before I share the points, though, I just wanted to encourage you guys to remember Micah 6:8, where the Lord tells us to seek justice, to love mercy, walk humbly with our God. And, you know, it's not always easy to do those things. And so I want you to, you know, as you're growing up and learning and thinking about being lifelong learners and what that means to you, to try to do that, pinpoint where you're at in life and how you're treating others. Are you crawling in their skin? Kind of how some of you had to do today with Barbara or Cheney. And just, are you walking humbly with the Lord and looking at justice and taking care of others, especially those that can't speak for themselves. So that's why I love Judge Geip's advocacy for speaking for those who can't. I had another Atticus Finch quote because he did the same thing and I love him, but I won't give you that. So I know you're waiting for the points. Okay, pretty sure I tallied everything right. So what I'll do is I'll share trial 1's points and then trial 2 and talk about the average and the overall points. So for trial 1, the plaintiff was Kirkland Kent team, right? And Issaquah North Bend was defense. For that round, for trial 1, the plaintiff's Kirkland Kent team earned 87 points and Issaquah North Bend earned 79. During trial 2, when Kirkland Kent was defense and Issaquah North Bend was plaintiff, let's see here, I cannot speak. Kirkland Kent, that's such a tongue twister, earned 91 points, whereas Issaquah won 69 points. So overall averages and total point score gives Kirkland Kent team 178 points and Issaquah North Bend 148 points. So thank you. So everybody give a round of applause, or I don't know, how do you do it when you're not? We'll do sign language applause right now.
Sign language applause, that's right.
Sign language applause for Kirkland Kent. But again, you guys, oh, there you go. Fine. That's good, Ashlyn. Yeah, your little emoji thingy.
Hannah started it first, so I was like, oh yeah.
Yeah, there we go. I know, right? All the technical aspects of Zoom. And yes, I should have mentioned earlier, Judge Guy, thank you. We're talking about Challenge B, which is kind of like 8th grade level students, right? So they're still in that middle schoolish kind of morphing into high school. But of course, you guys are classically educated, so you know you're kind of equipped with a little bit more learning. So I couldn't agree with him more about your polishedness, putting things together, working hard, and just congratulations to both teams. I can Maybe I'll just say a prayer right now to close this out, if that's okay, Lenore. I know that you're on, but I don't see your mic.
Yes.
I want to let everyone know I've got about 10 more minutes. If you have any other questions, I'm willing to stay on the line, okay?
Awesome. Okay, I'll say a quick prayer and then I'll kind of hand it over to Lenore and then Judge Geip and you guys and how we're going to work the last 10 minutes. So I'll pray. Lord Jesus, thank you so much for today. Thank you for helping to sort out nerves, and thank you for allowing our students to have the opportunity to share all the hard work that they have put in these past 15 weeks and learning about our judicial system, learning about crawling into other skins, and learning to look at what justice looks like and to love blindly, to consider those innocent until proven guilty, and to just lavish upon everyone humbleness and kindness. I thank you so much for Judge Geip and all of his guidance and how gentle and kind he was with the students today, especially given that this is our first time going through this. I thank you for the parents who helped put in long hours of not coaching, even though you just want to help your student lead to a better form of a question, but really allowing our students to dig into what they were looking at. And I just thank you for the directors of these campuses, because we had to join forces together to make it happen because we have such small communities. So I thank you, God, for working out those details. Thank you, Lord, that you are a God of justice, that you're a God of mercy, and you also are a God of peace. We thank you that ultimate justice lies with you and what Jesus has done on the cross for us. And again, we just thank you so much that we get to educate classically and we get to equip our students with the skills they need for the future. Thank you for this opportunity, Lord. Amen. Okay, I'm gonna bounce off and leave it to Lenore and Judge Geip and any other questions or things that you need. And directors, you can contact me directly for things.
Yes, do we have any questions?
What verdict did you find on each of the cases?
You asking me if I would have found one?
If you would have found a verdict, what would you have given?
Oh, the nice thing is I never have to do that unless unless the jury's been waived. So that's almost never happened that I'd have to make that decision myself on a criminal matter. In the first round, I would have found guilty based upon the admission of the confession, and the fact is that the order of sequence of the bullet wounds that was brought out in the first prosecution, showing that the head wound was last and it was the fatal one after he was already on the ground. It's premeditated, even if the first shooting in the arm or the second shooting in the back, even if those could have been something other than premeditated, going up and putting one in the back of the head and killing him is premeditated in that moment. So it would have been guilty. The second one would have been not guilty because the evidence about the sequencing didn't come out and the confession didn't come in.
Thank you so much, Judge Geip. Can we, as a community, give our judge a round of applause as well?
Oh, it's not
Thank you
necessary.
for your time, sir. Thank you.
Thank you.
As host of this meeting, I'm officially declaring our mock trial completed. Thank you to everyone. We hope you have a wonderful summer. And yeah, if you want to come experience more, we will find a way for more opportunities like this.
And if any of you want to come to the court and see court in action when we're reopened, let me know. Your administrators know how to contact me. And it's always something I encourage young people to do, is to see how criminal court works at least once in their lives, even if they're not intending to go into the profession.
Excellent. We would love to take you up for a field trip. Thank you, Judge Geip.
Thank you. Have a good day.
All right. Good afternoon, everyone. I'm officially ending the meeting.